Brenda, are you there? This is Glenn.
Yep, we're all here, Glenn.
Okay. Well, okay. It is now time to call this meeting of the Board of Minerals and Environment to order. Brenda, would you call the roll?
Ewing,
Here.
Grunwald,
Here.
Haig,
Here.
Carpin,
Here.
Miller,
Here.
Morris,
Here.
Schultz,
Here.
Greenfield,
Here.
and Bloomhart.
Here. I would like to welcome everyone participating in today's meeting or listening online. For the benefit of our online listeners, I would request that all participants, including board members, please identify yourselves when speaking. Please keep your microphones or phones muted unless speaking. This meeting is streaming live on SD.net, a service of South Dakota Public Broadcasting. The meeting is also being recorded, and the audio will be made available online following the meeting. To find the audio recording, do a web search for South Dakota Boards and Commissions portal, follow the link, and select the name of the board. First thing on the agenda is to approve the agenda. Could I have a motion and a second to approve the agenda, please?
Miller seconds.
We have a motion and a second. Do we have further discussion? Hearing none. All in favor of the motion signify by saying aye.
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 Opposed? Nay. The motion is carried. At this time, because I'm out of state yet, I would ask Vice Chairman Greenfield to conduct the rest of the meeting. I'm passing the gavel to you, Greg.
The next item on the agenda, item number 3, is approval of the February 19th, 2026 meeting minutes. Is there a motion?
Ewing, motion to approve.
Carpin seconds.
We'll do a voice call. All those in favor of the motion approving the minutes signify by saying aye.
Aye.
Opposed?
Aye.
Aye.
Opposed, same sign. Motion carries. Fourth item on the agenda, transfer of a small-scale mine permit 397 from Wade's Gold Mill, Inc. to Robert Wade. Mr. Holm.
Robert Wade has requested transfer of small-scale mine permit 397 from Wade's Gold Mill, Inc. The general location of the permitted operation is approximately 10 miles southwest of Custer, South Dakota. Under SDCL 45-6B-47, any mine permit can be transferred from one operator to another, with the accessor operator assuming all reclamation liability. The complete transfer application form was submitted on February 2nd, 2026. The $100 transfer fee was submitted on June 17th, 2025. The $11,900 replacement surety was submitted on February 10th, 2026, and the application was determined complete on February 10th, 2026. The recommendation to transfer the permit was prepared on February 12th, 2026, and it was published in the Custer County Chronicle on March 4th and 11th, 2026. We did receive the affidavit of publication on March 16th, 2026, and the notice was also on the DANR public notice webpage. No intervention petitions were received. Under SDCL 45-6B-47, the board cannot deny a mine permit transfer unless the operation is not or cannot be brought into compliance with all applicable federal, state, or local laws, or the successor operator is in violation of state mining laws or mine permit conditions for any mine operation in the state. The current mine permit and Robert Wade are in compliance with all federal, state, and local laws and regulations. Robert Wade also submitted a certification of applicant form and disclosed no violations. Regarding the replacement surety, DANR currently holds a $1,000 CD, and the U.S. Forest Service holds $4,500 in reclamation bonding, for a total of $5,500. DANR reviewed the mine permit transfer application. DANR reviewed the reclamation surety and calculated a replacement surety amount of $11,900. Since the maximum small-scale reclamation bond amount has been increased from $2,500 to $38,500, the U.S. Forest Service has agreed to allow DANR to hold the entire $11,900 reclamation surety per the MOU between DANR and the Forest Service. Upon acceptance by the board of the $11,900 replacement surety, the existing $1,000 CD held by DANR will be released to Wade's Gold Mill, Inc. Our recommendation is to transfer small-scale mine permit 397 and liability from Wade's Gold Mill, Inc. to Robert Wade, accept CD number 6601016434, First Interstate Bank, Custer, South Dakota, in the amount of $11,900, and release CD number 80138, First Interstate Bank, Hill City, South Dakota, in the amount of $1,000.
Are there any questions for Mr. Holm from the board? Are there any motions?
Carmen moves for the transfer of small mine permit 397.
Miller seconds.
Motion and a second. Is there further discussion? Hearing none, Brenda, please call the roll.
Ewing.
Aye.
Grunwald. Haig.
Aye.
Carpin.
Aye.
Miller.
Aye.
Norris.
Aye.
Schultz.
Aye.
Blumhardt.
Aye.
And Greenfield.
Aye. Next item on the agenda is the annual update of post-closure financial assurance for Homestake Mining Company, mine permits 332, 456, and 445. Mr. Holm.
I'll start with the post-closure bond for permits 332 and 456. In the May 18th, 2006 order regarding the post-closure financial assurance for mine permits 332 and 456, it states the financial assurance shall be automatically extended for periods of 1 year. At the time of each annual extension, the face value of the financial assurance shall be adjusted to the bonding schedule set by the board in 2006 and updated in 2012, 2018, and 2023 during the 5-year financial assurance reviews. For 2026, the face value of the surety bond that serves as a post-closure financial assurance is required to be $86,035,509. This is an increase from the $84,056 amount which was submitted last year. For the increase, Homestake submitted a rider to the surety bond number 82336310, Federal Insurance Company, which increases the amount to the new face value. Federal Insurance is licensed in South Dakota and is on the U.S. Department of Treasury list of approved surety companies. Ratings for the company from AM Best, Standard & Poor's, Moody's, and Fitch's are superior, very strong, high quality, and very high credit, respectively. Outlooks are all stable. Our recommendation is to accept the rider to surety bond number 82336310, Federal Insurance Company, increasing the post-closure financial assurance amount to $86,035,509. Did you want me to continue on for permit 445 too then?
Yes.
Okay. For mine permit 445 and the post-closure conditions which were approved by the board on January 21st, 2016, it states the financial assurance shall be automatically extended for periods of 1 year. At the time of its annual extension, the face value of the financial assurance shall be adjusted to the bonding schedule set by the board in 2016 and updated in April 2022 as part of the 5-year financial assurance review. For 2026, the face value of the surety bond that serves as a post-closure financial assurance is required to be $42,939,910. This is an increase from the $41,773,222 amount which was submitted last year. For the increase, Homestake Mining submitted a rider to surety bond number 091-77703, Fidelity and Deposit Company of Maryland and Zurich American Insurance Company, which increases the amount to the new face value. Both surety companies are licensed in South Dakota and are on the U.S. Department of Treasury list of approved surety companies. Ratings for both companies from AM Best, Standard & Poor's, Moody's, and Fitch's are superior, very strong, high quality, and very high credit, respectively. Outlooks are stable. As part of the January 21st, 2016 conditions approved by the board, the department is required to do a review of the permit 445 post-closure bond beginning in 2021 and every 5 years thereafter in order to recalculate and update the bond. The next 5-year review is scheduled for this year. The department will begin its review this spring with a revised post-closure bond amount anticipated for board approval before the end of this year or early 2027. Our recommendation is to accept the rider to surety bond number 091777703, Fidelity Deposit Company of Maryland and Zurich American Insurance Company, increasing post-closure financial insurance amount to $42,939,910.
Are there any questions for Mr. Holm? Are there any motions?
Carpenter moves to accept the recommendation of the department on permits 332, 456, and 455, and accept the rider of the bonds for each accordingly.
Grunwald seconds.
Grunwald seconds. We have a motion and a second. Is there anything that we need to do in addition, Mr. Holm?
No, just board approval of those amounts.
All right. We have a motion and a second. Is there any further board discussion? Mr. Morris?
I believe Mr. Carpenter said 455, it should be 445.
Are you amending your motion?
Yes, sorry for the misspeak.
Any further discussion with the board? We have a motion. We have a second. Brenda, please call the roll.
Ewing.
Aye.
Grunwald. Hague. Carpin.
Aye.
Miller.
Aye.
Morris. Schultz.
Aye.
Blumhardt.
Aye.
Greenfield.
Aye. Next item on the agenda is the mining issues consent calendar. Mr. Klein.
Chairman, I'm here to answer any questions the board may have in regards to consent calendar.
Yeah, we're going to do this with everybody. If you could sit down, turn on the microphone, tell us who you are, and then we'll go forward.
My name is Tom Klein, here to answer any questions the board may have in regards to the consent calendar.
Any questions of the board? Any motions?
Ewing motion to accept the consent calendar.
Miller seconds.
We have a motion and we have a second. Do we have further discussion? Hearing none, Brenda, please call the roll.
Ewing.
Aye.
Grunwald. Hague.
Aye.
Carpin.
Aye.
Miller.
Aye.
Morris. Schultz.
Aye.
Blumhardt.
Aye.
Greenfield.
Aye. Next item on the agenda, request for the board to overrule pre-hearing orders issued by Hearing Chair Morris in the matter of Clean Nuclear Energy Corporation uranium exploration permit application capital EXNI 453. Before we start, I would like to try to set some rules as to how we're going to proceed. First of all, even with the attorneys, I'll give the attorneys the opportunity to make their arguments first and then open it up to the interveners. Even the attorneys, if you can come forward, make your arguments, turn the microphone on, identify yourself, and after you're all done with your presentation, turn the mic off, go back to your seat. We have a difficulty with a court reporter trying to transcribe what is happening in a hearing if it's happening all over. We need the transcript for purposes of appeal to all occur up in the front. So that's my goal today, is that we get the testimony coming from right here in front of me. Make your arguments and then please be seated. And in order to come forward, you need to be recognized by me, the chair. We have sent out a notice of hearing of what we're doing today, which was sent out into the interveners. In that notice of hearing, it listed the specific orders to be discussed, and they are numbered. Number 1 is change of venue. Number 2 is the Fall River County ordinance. Number 3 is the applicant's motion in limine to preclude evidence regarding mining. Number 4 is the order relating to translation services. Number 5 is the electronic service order. And number 6 are other orders issued by the hearing chair at the request of the parties or the interveners. I intend to follow the notice of hearing order in making the presentations. It is the interveners that made the motions for the review, so I would ask an attorney for the interveners to come forward on issue number 1. Bruce or Jay?
Okay, I'm not representing other interveners, I'm intervener.
Okay, are there any attorneys that are here? Any attorneys for any of the interveners or the parties? Mr. Davis, if you could kindly announce who you are and who you represent, and remember to, your microphone is on.
I believe it is. Good morning, members of the board. I'm Jay Davis from Rapid City, South Dakota. I'm actually a retired attorney, chair of the South Dakota chapter of the Sierra Club, but I'm also an individual intervener in this matter. Concerning the request for change of venue, I would submit that in all probability, this is the most controversial, momentous issue that's going to come before this board in 2026. There are literally dozens of individual interveners in this matter, all of whom live in the Black Hills or on the Pine Ridge Reservation, or virtually all of whom do. Indeed, all of the parties to this matter, including even Mr. Nas, the attorney for Clean Nuclear Energy Corp., reside in the Black Hills. As a matter of openness and transparency, it is really desirable that this hearing be held in Hot Springs, the county seat of Fall River County, where the proposed uranium exploration would take place. As you're aware, the local government bodies, the Oglala Lakota County Commission, the Fall River County Commission, and the Hot Springs City Council have all asked that this hearing be transferred to Fall River County, and they have put up their shares of the required financial amount to cover the costs of state employees going to Hot Springs for the purpose of the hearing. I would ask the board to find that the application for change of venue is in substantial compliance with the law, and to grant the change of venue so that this hearing can be open to everyone. The hardship of traveling to Hot Springs for a 3-day hearing is far less than the hardship of traveling to Pierre and staying here for a 3-day hearing for many of the interveners. Some of us can afford 3 nights in a motel, but not everyone who has a huge interest in this controversial issue can afford that. So with that, I would just ask that the venue be changed to Fall River County.
Thank you, Mr. Davis. Are there any other attorneys for the interveners?
Mr. Greenfield, would it be possible to let Mr. Shark go before me? He has done extensive work on this, and I would then follow up with him with the...
Yes. Yes.
Thank you.
Good morning.
I'm Dr. Ben Sharp. I'm an intervener in this matter. I've also brought with me Bob Nelson, who's the mayor of Hot Springs, South Dakota, the largest affected community in this matter. I think I'm going to make a somewhat more pointed intervention than the one you just heard. We're not, technically, I don't feel like asking for leeway in consideration of the venue change request, because the venue change request was submitted on time and completely lawfully. I think it is disingenuous and, if not outright dishonest, to suggest that the venue change that was received by the Minerals Board was out of time because Fall River County submitted their request on October 15th. The legal, lawful, and on-time request was submitted by Oglala Lakota County on the 14th of May, which was absolutely within the time. The statute reads very clearly, county commissioners of a county containing affected land. That's SDCL 456027. Nobody's contesting that Oglala Lakota County is affected land, which means that application for venue change was sent and received on time and completely lawfully and appropriately. What's disingenuous was that the hearing chair on the 6th of January, or actually on the 21st of December, and been repeated in the in-person hearing on the 6th of January, made no reference at all to the legal and lawful and on-time request by Oglala Lakota County. Instead, made a large issue out of the fact that Fall River County joined that petition on October 15th, saying that it was out of time and therefore it shall be denied. And then in the final words of the order, in addition, all other requests to change the venue of the hearing of EXNI 453 from Pierre to another location is denied. I think he meant are denied, it's plural, but I'm reading it correctly. To dismiss the legal and lawful request with a single word without even referring to the fact that it existed is actually quite disingenuous. And I don't think that there is any legal basis under SDCL 6027 for this board to reject a lawful and timely request. Furthermore, this board, after those were both received, came back to the counties with a request to come up with the money, $5,870. And the counties, along with Hot Springs, South Dakota, came up with the money. If the requests were being rejected on procedural grounds that it hadn't been received on time, why were we told how much money we needed to raise? I think this is a very, the rejection was wholly inappropriate, and I think it needs to be absolutely reversed on purely procedural legal grounds. I also will quote from you from the Rules of Administrative Procedure. In South Dakota, interveners in contested cases before the Board of Minerals and Environment may present relevant evidence, including testimony from public officials, provided it is not privileged and adheres to rules of relevance as guided by SD Admin R 7409-0104. Is that right? I'm sorry. I can provide you the text. I don't know how to read probably the way that you refer to laws anyway, but SD Admin R 7409-0104 and Codified Law 15-6-26B. The chair of the hearing controls the admission of such evidence, ensuring it pertains directly to the contested issues. On that basis, I brought with me Bob Nelson, the mayor of Hot Springs, who was involved in obviously approving the release of funds outside the budget cycle in accordance with the wishes of the citizens of his town. And he has a letter that he prepared to present here consistent with that rule.
Good morning.
Good morning.
As Ben said, my name is Bob Nelson. I'm the mayor of the city of Hot Springs. On Monday night, we had a council meeting and council approved a statement that they wanted me to share with you folks. Some of what's in that statement, I'll be repeating what Ben has said. I'm addressing the South Dakota Board of Minerals and Environment in my capacity as mayor of Hot Springs. with the endorsement of the Hot Springs City Council. As elected representatives of the largest directly affected community in Fall River County, we have a responsibility to speak on behalf of our constituents regarding proposals to explore and mine for uranium in Fall River County. As a public board appointed by the governor of South Dakota, we believe it's your responsibility to hear and consider this submission on this matter. I want to speak to two decisions made by hearing Chairman Bob Morris, which have now been appealed and are up for consideration before the full mineral board. The motions I'm speaking to here are, number one, the decision to deny the request of the counties of Fall River and Oglala counties, and supported by the Hot Springs City Council, to change the venue for the public hearing to a West River venue, Hot Springs, Rapid City, or Pine Ridge. Number two, the decision that the board will not recognize the applicability of the Fall River County ordinance declaring that uranium mining is an unlawful nuisance in Fall River County on the grounds that uranium mining and uranium exploration are separate activities. I strongly feel that it is the duty of all public officials, including appointed members of a government body like the South Dakota Board of Minerals and Environment, to faithfully enact relevant laws in the spirit of representing the will of the citizens in a fair and impartial manner. The county commissions of the most affected counties in this manner, Fall River County and Oglala County, and the City Council of Hot Springs, the largest affected county, voted unanimously to approve the expenditure to cover the cost of the venue change. These aren't wealthy counties, but the citizens clearly believe the hearing should be held locally. Given a choice between expecting 30 to 40 registered interveners and all interested members of the public to travel to Pierre and secure accommodations for a multi-day hearing versus supporting travel of 7 members of the Mineral Board who are themselves residents in different counties around the state, it is reasonable that the hearing should occur closer to the affected citizens of the interveners. Chairman Morris justified this rejection on the venue change request on the basis that the request from Fall River County, as required under South Dakota Codified Law 45-6D-27, was dated October 15th, 2025, more than 20 days after the publication of the notice. South Dakota Codified Law requires that the county commissioners of a county containing affected land may request the venue change. The first public notice of the permit application was the beginning of May 2025. Oglala Lakota County requested the venue change on May 14th, 2025, which is before the required 20-day deadline. There is no dispute that Oglala Lakota County is an affected county. Chairman Morris's order makes no mention of that legal and proper request. As required by South Dakota Codified Law 45-6D-27, why did the state provide the cost, $5,870, to move the hearing if a valid request had not been received from Oglala Lakota County? The fact that Fall River County joined Oglala Lakota County to support their request on October 15th, 2025, only adds legitimacy to the Oglala Lakota County's request for a venue change. To interpret the request by Fall River County as disqualifying ignores the fact that a legal and proper request from an affected county had already been received. The citizens of the affected counties have a right to insist that any procedural hearing informing decisions affecting our lives should occur locally. On that basis, Chairman Morris's order regarding the venue change should be overturned. As correctly noted in Chairman Morris's order dated December 22nd, 2025, the citizens of Fall River County voted on August 11th, 2022.
This is the other order. We might as well take them and see. The rest of the letter refers to the other order.
Yeah, let's wait.
You wanna separate those?
You can come up again to talk about the effect of the ordinance. We're going to try to thank you for your testimony. Do you have anything further?
I'll take your guidance.
On this issue, on the change of venue,
On the
do you
change
have
of venue?
anything further?
Well, in my opinion, what I have to say is directly affects the change of venue.
Would you like to admit into evidence your letter?
Do I still get an opportunity to read it?
Yeah.
Okay.
You're under two different topics, that's all.
All right.
Yeah.
So call me back when you need me, and I'll finish the rest
Yeah,
of the
we'll
letter.
figure, yeah,
How's that?
when we talk about item number, give me a second. We will talk to you again on item number 2.
All right.
All right, thank you.
Thank you.
Thank you, Ben. If you can both turn your mics off. There we go. Are there any other attorneys for the interveners and/or interveners that wish to appear on item number 1, motion for change of venue? Mr. Card. Oh, are you ready? Sorry.
Bruce
Are
Ellison.
you ready?
Yes, I was wondering if someone had snuck in
No.
before me that I didn't
No.
see. Good morning, ladies and gentlemen of the board. My name is Bruce Ellison. I'm an attorney in South Dakota for a little over 50 years now. I'm now in semi-retirement, so I guess I'm in my recovery stage. But I'm appearing here as an individual intervener and not on behalf of any other organization. Certainly, I represent my children and my grandchildren as part of this, but not in the official capacity, but as their father and grandfather, and as a landowner. The whole idea of a change of venue statute, as I understand it, 456027, is to try and have affected counties, as the doctor pointed out, but really the people and the lands that are affected in any way. And there's no question it's been recognized by the EPA, by the NRC, and even by this board in the past that Oglala Lakota County is downstream from these operations. Any contaminated water that results from this operation, as well as the mess that already exists, flows into the Cheyenne River, which flows into Angostura, which flows into the Cheyenne River and impacts Pine Ridge. It also impacts Cheyenne River reservations, flows directly underneath it. This aquifer also is part of the this flow of water is also part of the recharge for the aquifers, for some of the aquifers under the Pine Ridge Reservation. 456027 of our South Dakota codified laws say that within 20 days, any affected party can seek a change of venue. And as has been pointed out, the first party to do so was the first county to do so was the Oglala Lakota County Commission. And one of the things that I'm a little concerned about, Mr. Greenfield, I appreciate you bringing it up and suggesting that the doctor introduce a document into evidence. What I'm going to hand to each of you, and I hope I have enough copies, is a letter dated May 14th, 2025, from the Oglala Lakota County Commissioner's office. And let me do that first, and then I want to address the document. Although I'm not going to read it, I believe that Mr. Gunhammer will do that later.
If you could provide that to the reporter, we'll get them all marked that way.
Yes, sir.
Yes, sir.
Mr. Chairman, if I may ask, Mr. Ellison, has this document previously been provided to the Board of Minerals and Environment? Is it that letter?
It is that letter. I'm not sure it's part of these proceedings. I want the members of the board to have it in front of them while I discuss the letter, some aspects of the letter. So I'm not sure it's part of the record of these proceedings other than meetings. However, at this time, I want to make sure that each member of the board, although I understand that a packet was presented to the board, I don't know if it includes everything.
It is part of the record.
All right,
You're referring to the May 14 letter?
yes.
Okay, we have that. That's part
We
of the
have
record.
that.
It's on the open
Thank
meeting
you.
site.
Thank you.
Is there an objection then to this letter being marked? Oh.
I'm bad with these microphones. Yes. We'll go A for you and numbers for the others.
Could you distribute those? Could you want me to distribute those? While this document is being distributed, one of the reasons why I thought it was important that I present this to you as part of my arguments and why the hearing examiner's decision to not move the venue to at least Hot Springs is that I think it's important that I'd like to suggest that you have the document in front of you. You got a packet of materials, you have a lot to read. And there's some things specifically that I want to make sure you're aware of in reaching your decision in this matter. First of all, was pointed out by Dr. Sharp that a letter dated May 14th, 2025, which has been marked as Exhibit A, was sent to the DANR. However, it was sent as a comment. And maybe this is the reason why it was somehow missed earlier. Because unfortunately, this board, when it takes comments from the public, it either doesn't read them or it doesn't listen to them if they're orally presented, which I really think is unfortunate and a due process issue, because many people presenting public information, public testimony, have important things that you should consider in your decision making. So first we see the letter dated May 14th. We know it was received by the DANR prior to the 20 days of the running, because there's a stamp on it that says May 19th, 2025, received minerals and mining program. But as Dr. Sharp said, it was not discussed in the order that Mr. Morris executed in this particular matter. So it's timely. I would also note for the board that the Oglala Lakota County Commissioner's office is at 906 North River Street, Hot Springs. Because all the official meetings, that's where it's supposed to be taking place. And so we have a timely submission for a change of location to Oglala Lakota County and affected county that was presented and received by this board, but apparently ignored in the final decision. There is also another letter dated, it's actually undated, but it was a 2026 letter from the Oglala Lakota County on this issue, and I'd like to have this submitted as Exhibit B.
Could you provide a copy to the other attorneys too? Is this already part of the record? Do we know?
That's what Mr. Nass told us, but I believe so.
I've not seen this one.
Okay. I believe it was attached to other pleadings, but.
Mr. Allison, could you indicate where this has previously been submitted to the record?
Well, one place it was submitted was to the Department of Agriculture and Natural Resources on January 27th, 2026, as stated on the front page, upper right-hand corner of the document.
So it would be part of the record already, but that's fine. We'll mark it. Are there objections to the entry?
For the record, yes, Mr. Chairman, I would object to foundation, frankly. Thank you.
I'm going to overrule the objection since it's already part of the record, and it can be marked as Exhibit B.
I would also state that this is a self-executing document in the sense of, or self-authenticating document, which under the rules is by itself admissible, as I understand it. So what you have before you now is Exhibit B, which is an undated letter that was sent by the Guadalajara Commission that was received according to the stamp in the upper right-hand corner on January 27th, 2026. It was basically supplemented the arguments of the commission on this particular issue, and I thought it would be important to have as part of the record and for the board's consideration. And again, noting that the address for the Guadalajara County Commission is on North River Street in Hot Springs. As Dr. Sharp pointed out, there was also a letter sent from the Fall River County Commission. Find it. Yes. Oh, I apologize. One of the things I would like to request that when we just talk about the venue, that we talk about a location where there can be tables for everybody so that we could be kind of pre-sorted out as a little bit better than we're able to with just chairs. Okay. As I understand it, there was a Fall River County Commission letter that was sent. Excuse me 1 minute. Can I have just 1 minute, please? October 15th, that's what I thought. Okay.
Are you referring to the October 15 letter?
Yes, sir.
Okay. That's also part of the record.
Very good. So it should be edited. I would like to have that remarked exhibit here in C, please.
Any objection?
Just to be clear, this is part of the administrative record on file in this matter already, is that correct?
That's correct.
Okay, no objection.
Yes, please. C.
Exhibit C.
And again, one of the reasons for showing you Exhibit C is to note not only the proximity to the earlier filing request. You know, one of the things that has been clear is that, and I've mentioned this before, but I think it's apropos again to repeat it. If the purpose of these hearings is to promote the greatest input by the people of the state of South Dakota, or within the state of South Dakota, to any proposed permit that is under application by this board, that's the kind of, it seemed to me, the circumstance that whether a letter is written 4 days after a deadline that otherwise sets in other statutory deadlines, which you've already passed already, including the final hearing. If the emphasis is to promote due process, I would hope that this board would welcome a county coming in, even if it's a few days late from what the statute says, because the import, the purpose of the statute to allow for the participation by the people should be what this is all about. So we have another county, we have the immediate county being affected, Fall River County, also seeking for the venue of the hearing to be and if you'll look, most of the interveners, aside from some of the indigenous nations, are from Fall River County. And while the ordinance is to be discussed later, the overwhelming passage of that ordinance shows this is a very important topic in that county. As Dr. Sharp stated, and I'll just briefly reiterate, we were asked to pay for this. That's fine. That's what the statute says. Efforts were made by people in Fall River County, in Hot Springs, and in Oglala Cody County to raise this money that the board gave us as a figure for all of your costs at this hearing. And we did that. And I think the mayor may address that a little bit too, because the city's chipping in. It's important. I would also ask you to note that, again, looking at Exhibit C, the address for the Fall River County Commission is the same address as the Oglala Cody County Commission. 906 North River Street in Hot Springs. I have another letter that was received by the Board of the Minerals and Mining Program in January of this year, which again supplements its arguments, and I'd ask that be made of the record, part of the record as Exhibit D.
Any objection? It's part of the record. Take a look. That's part of it. Oh, I got one more.
Mr. Ellison, what's the date on that letter?
There's no date, but it was received according to the front page by this board or this program, January 29th, 2026.
Thank you.
Thank you. Has to be marked Exhibit D.
Any objections? Thank you. You can go ahead and mark the exhibit. It's marked.
I'm not going to make any more comment on that document. Again, it may be referred to by others, but again, strong enough feelings that the commission took it up twice and wanted you to know how important they felt about it. I believe the mayor's letter that was dated May 13th has been received and is before you as an exhibit from Dr. Sharp. And so I will not, do you need additional copies of that? Because I do have additional copies if there were not enough when that exhibit was received. Mr. Greenfield?
I don't think we do.
Okay. I don't believe, though, that there was was the October 20th letter, Ben? Did you submit that? I didn't. Okay, I have it.
I only thought it was on record.
Mr. Chairman, Mr. Temporary Chairman, when you spoke to Mr. Sharp, Dr. Sharp, about the letter from Hot Springs, you asked that it be perhaps made a part of the record. Dr. Sharp, I don't believe, submitted it to be a part of the record. He has just provided me with an original copy. We'll go back to my Exhibit E in a moment, if we could have this letter marked for Dr. Sharp.
Mr. Chairman, I do need to object to this document. While I don't object to its foundation, it's not been provided before today. This is an appeal of a previous decision made. While I don't object to evidence already submitted as part of the record being included today or considered, I do think it's inappropriate to consider new documents and new evidence at this appeal, frankly, Your Honor. Mr. Chairman, thank you.
I'm gonna overrule the objection and consider it as evidence. Objection noted.
Sir, would you?
Hold on just a second. Where is the letter? This one?
Yes. How do you want it identified, sir?
E.
That's E? Okay.
Do you want me to just mark your other one? Or I can-
That could be F, sure. Please.
Yeah, me too. Yeah. I may get that.
F, this would be F, okay. Thank you.
There's an Exhibit F that needs to be provided. Did you mark an F? You need to see F.
Mr. Chairman, there's no received stamp on Exhibit F that I see from DANR. I don't know if it's part of the record already. The October 2025 letter from the City of Hot Springs.
Give us a second. We need to look at it first.
What was the date again?
October 2025. And my purposes of asking, Mr. Chair, while Mr. McVeigh is looking, is to impose the same objection that I previously stated.
Mr. McVeigh says this is part of the record. So your objection would be overruled.
Thank you. I have no further comment on that exhibit. And one final exhibit. I have one final document. I have a copy of an email that was sent on January 22nd, 2026 from the Hot Springs City Administration Building that I'd like to ask to be marked as Exhibit G, please.
Please describe it again, Mr. Ellison.
It is there's a cover letter that was sent to Ms. Brinegar on January 22nd of 2026 by Ariel Allison, Allison, of the Hot Springs City Administration.
Thank you.
It contains a letter dated January 20th, 26 to Chairman Blumhardt. And if we could have that marked as G, please.
part of the record. No objection?
Correct.
Exhibit G is admitted.
And I think at least in terms of documents, that's all the documents that I have as Exhibit G is being distributed to you. I'm not going to refer specifically to the document. It, again, additionally emphasizes the city's keen interest. Where the overwhelming majority of the population lives in Fall River County, their interest in having this matter. It's their order. So I would urge you to overrule the hearing examiner's decision denying a change of venue, to recognize that Oglala Lakota County is an affected county as well as Fall River County, to waive the Fall River County's somewhat tardy, little tardy, request for this venue to be changed to Hot Springs, and to at least accept it as a supporting document by two counties that are joined at the hip, literally, by where they're located. You know, there are meeting places in Fall River County. The EPA and the NRC have held meetings there, formal meetings with the public, about these areas around this uranium. And so, on behalf of someone who's in a different place in the Cheyenne River Basin, but it's all about our water, without which we will have no future. And it's your job, I would submit, under, it's entrusted to you to protect our water. Please allow it to be heard in the community where people will be most affected and most impacted, and be able to participate. And you will show the people of South Dakota that, in fact, you are concerned about listening to them, hearing them, and not just being a rubber stamp for the company's request. Thank you.
Thank you. Any other intervener wishes to be heard prior to moving on to the applicant and the state? We have some, hang on, sir. We have, come on forward. Just
Mike's on okay?
You okay? We got to make sure. We good? Okay. Could you identify yourself?
Say good morning to the board. My name is Majana Paji Camp. I'm an intervener. I'm from Oglala, Lakota County. I am a father of 5 children. I have 6 grandchildren. I brought my wife and my daughter with me today. I'm a United States Marine. I was with the 1st Battalion, 5th Marines, and my wife is also a United States Marine. I wanted to speak today about the venue change. And, you know, Oglala, Lakota County, historically, we're the poorest county in the United States. And we have a life expectancy of 47 years old for our men. And it's important for us to have this venue change because there's a lot of our people who are affected by the uranium mining and the contamination of our drinking water. We're the people downstream from the Black Hills. And the Black Hills is sacred to my people. We don't want any destruction of any kind, especially to our water. We have a really high rate of cancer and many other diseases that are related to contamination of our drinking waters. And being that we do all of our business in Fall River County, it's hard for our people even to make it to Hot Springs. A lot of our people don't have vehicles or any way to travel to Fall River County. And for us to have to come all the way over here to Pierre, it's almost impossible. And I know of a lot of people who oppose any type of drilling or exploratory drilling because it's going to affect us directly. Our sacred sites, our water, and our future generations. We really know there's not a lot of drinking water left on this planet. If we took all the water in the planet and scaled it down to a gallon of water, we'd only have a tablespoon accessible for us to drink. And that affects all of us as humans, not just the people of Oglala Lakota County, my nation. So we really think it's important that we could get this venue changed to Fall River so that our people could have access to the board here to tell you our problems, to tell you our grievances, because we're really opposed to any type of mining or exploration in the Black Hills because we're downstream. As you know, whenever the water is affected, anything downstream, we're going to be the ones to drink this water. And historically, our people have suffered a lot from the Crow Butte mine, from the mines in the Hot Springs and Fall River. So for generations, we're still suffering. So it'll be a lot easier for our people to take part in the process, the judicial process that's going on here, because it's affecting us. It's our water. I want you guys to really think about that, because there's 45,000 of us, and we don't live very long. Our people are suffering, and we're looking to all of you to protect our water, to protect our families, and to give us a fair opportunity to come and for the rest of our people to speak in front of you. I just want to speak that much today about the venue change. I think it's really important to our people, and it's fair. And I believe that our Oglala Lakota County followed all the procedures to get the venue changed, so I really would like to ask you to please take this into consideration. It's really important to my people, my generation, and the generations after us. I want to say about that much. Thank you.
Thank you. There was one other person for, I've got one person coming up, and then you're free to come up. Are you coming up?
Good morning to the board. My name is Taylor Gunhammer. I'm an enrolled member of the Oglala Sioux Tribe, and I reside in Rapid City, where I am a citizen, and I try my best not to be a jerk. In a moment, I'm gonna bring up a couple of people who you probably all have never met, who can say why, I don't know. But I want to say about the venue change that there's been a lot of complication and obfuscation about this. Apparently, some people even think that evidence that already is on record has no foundation, which is a little crazy, but I'm not a lawyer. How would I know that? But what happened in this case is actually very simple. The people made a request, and Bob Morris moved the goalpost to a place he thought we couldn't meet. And then when we did meet those goals, and we means the people, the city of Hot Springs, Fall River County, and Oglala Lakota County. When we met those goals, Mr. Morris simply took his ball and went home. It was improper procedurally, and honestly, it really communicated to the citizens of this state that you consider our environmental future to be none of our business. And it speaks to a greater pattern of hostility to the citizens of this state who you are supposed to serve. I mean, you have Bob Morris repeatedly calling me a jerk on the record for asking questions. Very professional, Bob, love that. And I just saw Mr. McVeigh and Mr. Lees out in the hallway meeting with the leadership of CNEC, and the love was palpable. It was like a bunch of frat boys having a reunion
Mr.
over
Chair,
a beer.
can we get back to the reason for the change of venue?
We need to go to the reasons why you think that hearing Chair Morris was incorrect on his ruling on venue.
Okay. It's because the board has shown us at each and every turn that their goal is to reduce public participation and to reduce the availability of relevant evidence. And we are quite tired of this trend. And we are asking you with this venue change motion to reverse it and start serving the people of this state. Because frankly, even Governor Roden has now washed his hands of you. It's you. And so I want to say that much. And with that, I would like to call up OLCC Chairwoman Alyssa Comer and Wendell Youngbull.
Well, you don't get to call people up. I get to call people up, and I will you need to leave now and sit down.
Is that because there are laws that we should follow?
No, because you're out of order right now.
I'm out of order.
Yes, you're out of order.
So you don't want to hear from a county commissioner?
I do want to hear from a county commissioner.
Okay, that's what we're doing.
You need to vacate the chair. Who is the next person that would like to speak? Welcome.
Good afternoon, ladies and gentlemen. Let me get to this mic here. They say I speak soft, but to me, I think I do speak loud. Good afternoon. My name is Wendell Youngbull. I've been a commissioner for Oglala Lakota County for 16 years. 16 years. And I've always understood that the county, the 66 counties of South Dakota, was the grassroots with concerns with their constituents that reside in their counties. It is very important that they have a voice in issues that arise within the state of South Dakota. And in that 16 years of being there, my first pledge was I pledged that I would follow the rules of the state of South Dakota, which is very a tough issue that everyone is faced with these days. You know, you raise your hand and you swore an oath to uphold and protect the people of the state of South Dakota. And when you do that, that means it's troublesome when you have the grassroots issue arise and they have concerns with it. It's very difficult to make a decision when you have many parties deciding what needs to be the outcome. Today, I come before you because our constituents in Oglala Lakota County want a change of venue to be heard. I understand the dynamics, being a commissioner for 16 years, how emotional things can get and how things can get changed around and how individuals embrace that internal emotions. But one thing needs to happen, and we agreed when we raised our hand upon that Bible to uphold the oath to listen to the state of residents of South Dakota. And that's what we really need to do. The governor himself also raised his hand and pledged that he would support and listen to the people of South Dakota. If we cannot do that, then there is really a troublesome issue that we all face individually. For us, Oglala Lakota County, in a timeline, presented a change of venue. And we asked that. We know that you guys are pressed. We understand that. But we also understand that we need to hear from the people of each county to voice their concerns and give them a chance to hear. The decisions need to be made upon that, not upon anything other than what the people understand. And then that's your weight once you understand all the viewpoints of each and every one of the South Dakota residents. And I think that's what our chair lady here will emphasize that. We would request that you honor our request for change of venue. We have made additional, even though they say we're the poorest county of the 66 counties, but the main thing is this. We still listen to the people that have concerns concerning their issues, and some of that is water. And as human beings, we all need water, regardless of what social class that we represent. We need water, and we need to protect it at all costs, because we all live here. We enjoy the state of South Dakota because of its environment, its prestige, the Black Hills, the prairie, the hills, the mountains, everything that's there, the streams. So we have an obligation to ensure that our county residents get to enjoy that. And I think it's very important that we do. I thank you for listening to me today. I appreciate your concern, but I would really appreciate that we do honor our request as Oglala Lakota County. Thank you very much.
Thank you for your testimony.
Wendell Youngbull. Yeah.
Ma'am.
My name is Alyssa Comer. I am the chairperson of Oglala Lakota County Commissioners. I just would emphasize the same thing that Wendell had just said. I can't say it any better than him. But to consider the venue change, as we had sent the letter in May, dated May 14th, and as the gentleman graciously provided you a second copy of every letter that we had sent, I would just, for the people of the area, all of the locals of Fall River County, Oglala Lakota County, the people of Hot Springs and surrounding areas, please consider the venue change. Thank you. Alyssa Comer, C-O-M-E-R, Alyssa, A-L-L-Y-S-S-A.
Thank you. Anyone else from the interveners on item 1?
Mr. Chair, Roberta Hudson. I'm running the Teams meeting. We do have another person online that also wishes to make comments when you're prepared to take them.
Thank you. Welcome.
Thank you. Do you want me to wait?
No, go ahead.
All right. My name is Elizabeth Lonigal, and I'm a pro se intervener in this matter. This scheduling and venue appeal is brought pursuant to ARSD 74090108. I'm not asking the board to reach the merits of the permit application today. I'm asking the board to protect the integrity of its own process. The record before you is undisputed. This contested case involves 36 parties, including individual interveners, organizations, tribal governments, state agencies, and the applicant. The parties have identified at least 21 expert witnesses and more than 20 non-expert witnesses. Despite that record, a 3-day hearing has been set with express expectation that the matter would be concluded within that window.
Ma'am, I don't mean to interrupt.
I'm sorry, but the appeal that you're hearing today isn't just venue change. The appeal that we submitted was also for the length of the scheduling, and I will get to the venue change part of it.
Okay, let's just do venue change right now. There's an item number 6 where you can address your other concerns. That we need to deal with this in a topical fashion.
Okay. I just view that as another obstruction. The venue matter is more narrow, but the error is much more clear. SDCL 456027 provides that the Board of County Commissioners of a county containing affected land may request that the hearing be held in that county. The statute does not limit that authority to the county in which the drill sites are physically located. Oglala Lakota County contains lands previously affected by uranium exploration and mining activities in Fall River County and will be impacted by activities proposed under EXNI 453 as well. On May 14th, 2025, the Oglala County Commission timely and properly submitted a venue change request within 20 days of the last publication notice. That request complied with the statute. It was supported by additional letters from Fall River County Commissioners and the Hot Springs City Hot Springs City Council. It was further supported by motions and appeals from multiple interveners emphasizing accessibility, public participation, and proximity to affected communities. Despite that record, the hearing chair dismissed the request on the grounds that it must come from Fall River County. That requirement does not appear anywhere in SDCL 456027. The statute says a county containing affected land. It does not say that the county in which the application is filed, nor does it say the county containing the drill holes. The hearing officer's ruling improperly and illegally added language not included in the statute. In addition, the order denying the venue change compounds the problem. It does not correctly identify the government entity that made the request, and it does not state any proper nor applicable legal basis for the denial. That omission prevents meaningful review and undermines confidence in the ruling. This case involves uranium exploration in a region with a documented history of environmental harm and public concern. Venue and scheduling are not administrative conveniences. They determine who can attend, who can testify, and whether the public views the process as legitimate. Multiple local governments and numerous interveners have said clearly and consistently that a venue closer to the affected region would increase accessibility and transparency. That support deserves consideration under the statute, not outright dismissal by intentional misinterpretation and logistical annoyance. And I understand that Hot Springs is the venue that most people want to have have the venue changed to. And I understand that it's, maybe more comfortable because it's off reservation. However, Oglala Lakota County is the county that submitted the venue request. It is also contained within the Pine Ridge Reservation. Pine Ridge has a convention center that has rooms, restaurant, has everything that can be self-contained and at a price that is probably more affordable. And I am sure, in light of the fact that Governor Roden has made very clear efforts to rebuild bridges that have been burned by the previous administration, that the tribe would be open to hosting hearings like this, allowing their tribal members and affected citizens to be able to have presence at those hearings. So I would submit that should Hot Springs not be something that you find to be affordable or accommodating, I would suggest that perhaps your priority needs to be with the Oglala Sioux tribe. Thank you.
Thank you. That's exactly what I'm looking for. Topical. We have a call in.
Yes, Tanya. I believe it would be your turn now.
Tanya, are you there? Are you still showing that she's on the line?
I'm showing she's online and unmuted, but I don't see any sound. There's no sound coming through.
Well, these are difficult things. Let's see if we can get the sound. Tanya, if you can, we'll try to get your testimony in if we can figure out our technical glitches. Is there anyone else that wishes to appear on behalf of the intervener? The interveners, S, plural.
Good morning, Mr. Chair, board members. My name is Dr. Lilius Jarding. I live in Rapid City. I haven't really introduced myself to this body lately, but I'll do that at a later time. I would like to support the requests to overturn the ruling of the hearing chair and to change the venue to where most of the interveners are. And the interveners are primarily split between the Pine Ridge Reservation and Hot Springs. And the road to both of those places is not particularly longer if you pick one or the other, but both have facilities. The tribal facilities are more efficient and compact. So I would just like to join in asking that the ruling of the hearing chair be overturned. Thank you.
Thank you. Anyone else before I move on? Yes, ma'am, please come forward. Good morning. Good morning.
Good morning.
Good morning. Oh, sapsa wiaka luta e machape. Na hunku waki prahi haska na mi matho. Ate waki is ha prostanska na wiaka luta. Cha me naku chankpe opi helwati. Cha helta mahi be ampetuki. Na lebo michiklakinte.
Hello, my name is
yourself, please.
My name is Bud Lone Eagle Senior. I'm the translator for My name is Bud Lone Eagle Senior, and I'm the translator for Miss Helen Redfeather, and she comes from Wounded Knee, and she is requesting that the change of venue to Hot Springs, and because that is. And this is where she lives, and and she dwells there. And this land is we are the land protectors and water protectors of this land, and we can. There are going to be a lot more Lakota people if we change the venue so that people can be heard. Our people need to be heard on this matter.
Thank you. Anything else?
I want it down there to him when the New Year's he talked to. I want him to go down.
She wants them to be changed to change down there, to have the hearings down in Hot Springs, so that the people can be heard. They are all the people are affected by this uranium stuff that they're trying to bring to our people, which is not healthy for our people, and we would like the change of venue.
Anything further?
This is where we live. We can all speak for ourselves there, so we would like to change the venue.
Thank you.
Thank you, and I'm sure you guys are all going to do a good job on this. She says thank you.
Thank you. Anyone else for the interveners?
Hello, can you hear me now?
Yes. Is it okay if we take
Hi,
Yes, could you please identify yourself, your name, and where you're calling from?
my name is Tanya Stans. My Lakota name is Tokia Glahuniwe. I'm an intervener.
Yes, and you have comments on item number 1, the change of venue?
Oh, yes, I do.
Please share them.
Thank you. Well, just recently, on December 28th, there was a huge commemoration of Wounded Knee down on, Oglala Lakota County, a.k.a. Pine Ridge Res, a.k.a. Oglala Sioux Tribe. So the federal delegation included Rounds, Thune, and Dusty Johnson. So they came and took part, very respectful. But so to me, like, when you see something like that on a federal level where these, the delegates would come to the reservation and address us in a respectful manner, this is the same place that Oglala Lakota County put all their paperwork in to have the venue change. It's something that is required in the process. It shouldn't be ignored. But to me, if the federal delegates are good enough to come to the res, then how come the mineral board can't come to the res? Thank you.
Thank you. Ma'am, could you identify yourself, please?
Yeah, my name is Jean Roach. I'm an intervener. I'm from the Cheyenne River Sioux Tribe. Jean Roach. Yep. I'm in support of the venue change. A lot of our relatives are going to be affected by this. And I think that Tanya made a great point that, you guys could come down and see what, what's going to be affected or what has happened before with the radiation levels in our water. I think we need to address that issue, And I think if you come into the Black Hills, you'll see what exactly we're trying to protect. You know, the beauty and our historical and our spiritual connections are very important. And we're not here just for ourselves, we're here for our future generations. So being able to come together closer to where we live at would help everybody. I mean, if we have to come here, we might have to make a camp here. You know what I mean? We can't afford your rules. I mean, the accommodations are expensive. You know, everything's been cut already that people survive on. So, you know, we can always do that, but we prefer to be closer where we could travel back and forth to protect our cultural being from being raped. That's a word that we use, as rape in our Mother Earth, or sacred Black Hills. And that's the way we approach it. And we're very serious about protecting what little that has been taken from us. But this generation, our future generations, need to be heard. And we'd really appreciate you extending, what would the word be? Good faith efforts to understand the people that you represent. So, supported the venue change. I have more to say, so I'll be back.
Thank you.
Thank you.
Anyone else? Yes, ma'am.
Good morning, or is it afternoon already? Chairman and the board, my name is Karen Lerman. I live in Hot Springs, South Dakota, and I'm a wellness professional. I've been in Hot Springs for over 10 years. And since I've moved to Hot Springs, I have experienced several and been part of several hearings regarding concerns about mining issues in our area. And there's been, I don't think I need to cover all the evidence. The laws have already been discussed. The timeline has been discussed. There's been proper notification to bring this venue, but I just wanted to, you know, share a little more personal experience, because people come to me a lot because I'm passionate about this issue, and I'm not afraid to, I mean, I'm a little shaky, but, you know, I'll stand up to something that I believe in, because it's my values, and that's very, very important to me. But there are numerous people, there are thousands of people in our collective county and city that don't have the time, the resources, or the ability to come to Pier to be part of a public process. And it's a hardship for me. I'm a new business owner. I've just recently been in a situation where my income dropped, and I'm starting an entrepreneurship. And I've already lost 3 full days to come to these hearings. But again, because of, I believe in speaking up for what I believe and what's important, that's why I'm here. But it's with a lot of effort. And there are a lot of other people that would, if they could, be coming to Pier. So that is why we are passionate about this hearing being brought back to the area that's being affected. So thank you and for your consideration, and we'll see you again soon.
Thank you. Anyone else on behalf of the interveners? I'd like to continue.
I'm on the phone.
Hello?
I'm on the phone, and hello. I'm on the phone, and I don't know how to get to you without just unmuting my phone. And I have something to say.
We can hear you if you can identify yourself, please.
Okay, my name is Sarah Peterson. I'm an intervener, and I have some things written here, and most of it has already been gone over, but I do have a little bit more to say about the change of venue. We have 34 interveners, and most of them live in Fall River County, Oglala, Lakota County, and Pennington County. It is important for all the interveners to be able to attend the 3-day hearing and have a chance to speak and be heard. The expense of driving to Pier, a motel room, 3 nights, gas and food is difficult or impossible for some of the interveners. If they can't make it to Pier, their voices will be silenced. The state estimates $5,870 total for the estimated 4-day hearing in Hot Springs. The City Council can waive the rental for the Mueller Center auditorium. The general public of these 3 counties have the right to be heard and the right to hear what is being proposed for our counties. This will allow our citizens more public participation, education, and understanding of the issues and the decision-making process. It's a matter of local control. I am asking you to move the hearing on the uranium exploration permit to Hot Springs. Thank you.
Thank you. Anything further? I'd like to continue on, so the applicant, if you have your response and your argument, limited to change of venue.
Thank you, Mr. Chairman, members of the commission. Matt Nas for Clean Nuclear Energy Corporation. With me today are Jeremy Poirier, Mike Blady, and Benjamin Asuncion. This commission is controlled by statute, and you've heard reference to some statutes today, especially 45-6D-27, 6D being Delta. I'd like to quote the first 2 sentences of that statute. The Board of County Commissioners of a county containing affected land may request that the hearing on the application for a uranium exploration operation permit be held in that county. Such request shall be filed with the Board of Minerals and Environment not more than 20 days after the date of last publication of notice pursuant to section 45-6D-12, end quote. You've heard that several times this morning already. What you haven't heard is the statutory definition of affected lands, which is found in 45-6D-3, sub 1, which reads, affected land, the surface area disturbed by reason of the building of access roads or trails, leveling drill sites, storage areas, containment ponds, or other support facilities for the purpose of exploration, including the land affected by the surface subsidence, end quote. Affected land is only the land where the operation will occur. There's no dispute in the record that that land is all in Fall River County. There's also no dispute that the Fall River County Commission did not timely request the venue change to Fall River County. Mr. Moore's decision on venue wasn't just legally correct, it was legally required by application of the relevant statutes that control this board's decisions. Additionally, there are practical considerations at this point that recommend upholding the decision of the hearing chair regarding the venue. Arrangements have been made to be here in Pier for witnesses, for parties, in April for the upcoming hearing. We've already had to change those plans once. There's no reason to do it again. The decision was correct in the first instance and it should be affirmed. In addition, DA&R is here. We have a facility that works, and I think it's appropriate too to say that we have a facility here in the Capitol that includes security that we went through this morning. That's likely to be appropriate and needed in this process moving forward for this hearing. This exploration activity will occur in Fall River County. The affected land that is defined in statute is all in Fall River County. The Fall River County Commission did not timely request a venue change pursuant to 45-6D-27. That is the body who can request that venue change, as that's where the affected land lies. Thank you, Mr. Chairman.
Thank you. Mr. Blair.
Mr. Chairman, Steve Blair, General Counsel for the Department of Ag and Natural Resources. We've heard a lot of argument. I'm not going to belabor the point. I agree with Mr. Naz's legal interpretation regarding the definition of affected lands in the statute. I feel that that definition controls the language in 45-6D-27 regarding change of venue at the request of county commission in a county that contains affected land. And there's been no dispute that the Fall River County petition was untimely, and that the Oglala County petition doesn't meet the requirements of that statute. And for that, we'd ask you to uphold Hearing Chair Morris's decision on venue. Thank you.
Thank you. I see moving forward with the board making a decision on each of these as we proceed, rather than making one. Yes, Bruce.
Mr. Chair, I would hope that there would be at least a brief opportunity for response. The only thing that I would want to add, Bruce Ellison, intervener, is, you can do what due process requires, because again, statutes are only as rigid as you make them, and obviously we've already had a lot of waivers of time stuff. It's about due process. I just want to make a point about the security. I am offended by the suggestion that as this board does not hold this hearing in Pier with adequate security. Who's that addressed to? Are they afraid of the company? Are they afraid of themselves? No, they're afraid of people who raise objections about proposed corporate activity for the greed of a few at the expense of many. Or it's about racism. And I'm offended by both of those. Thank you.
Are you done?
Yes, sir. Thank you.
Do you have a response?
A suggestion of racism is patently offensive, and I take that very seriously, and am emotionally upset by even the allegation of that.
Order.
Thank you, Mr. Chairman.
Thank you. We're going to discuss. You're not recognized. The board's going to discuss. Is there a motion? Pardon me?
I have a correction to my testimony earlier today.
Come forward.
Okay, thank you. I just wanted to, my name is Taylor Gunhammer, sorry. I just wanted to make a correction. I believe earlier I said it was Mr. McVeigh. It was actually Mr. Blair who had the super friendly meeting with the CNEC officials in the hallway. And also it was racism. Thank you.
Ma'am.
I would like to point out that apparently the attorney for CNEC is completely unaware of the racism history that has occurred in this state with respect to his suggestions for security in an area that is primarily occupied by my people, by me. I live in that area. Do you find me to be a security threat? Do you? No. I'm the same skin color as you, but I'm Lakota. And the history of that suggestion in this state is offensive. And for that reason alone, to show that you don't have those same racist tendencies,
Mr. Chairman,
you
has
should
nothing
be
to do
changing
about
that
the
venue.
location.
Thank you.
Thank you.
This has nothing to do with location.
All right. Let's talk about number one and how we want to move forward. We've heard the arguments. Basically, the decision is, do we uphold Chairman or Chairperson Morris's ruling on venue, or do we change the ruling on venue? Is there a motion that anybody cares to make?
Mr. Chair.
Yes.
Jessica Grunwald. I would like to entertain the motion to change the hearing venue for permit application EXNI 453 from Pierre, South Dakota to Hot Springs, South Dakota in Fall River County.
Order. That is the motion. Is there a second of the motion?
Yes, Mr. Chairman, I'd second the motion. Gary Haig.
Motion has been made. Motion has been seconded. Is there further discussion amongst the board? Any further discussion?
Mr. Chairman, Carpin.
Mr. Carpin.
Yes, I'm assuming, I have no idea, I'm not familiar with the area, but I'm assuming they have accommodations for everyone to attend this. I'm speaking to the board members.
Anything else? Any further discussion? We have a motion, we have a second. Brenda, call the roll.
Ewing.
No.
Grunwald.
Yes.
Haig.
Yes.
Carpin.
Yes.
Miller.
No.
Morris. Steen. Schultz.
Yes.
Blumhart.
No.
And Greenfield.
Yes. What's our tally?
3 noes, 6 yes.
Motion carries. Order. We can't
Excuse me,
do
Mr.
that.
Chairman.
We
5
can't do
yes,
that. I
one
know you're
abstain.
excited. We can't do that. We need to have decorum. All right, item number 2. The Fall River County ordinance declaring uranium mining a nuisance. We will go in the same order with interveners going first, or counsel for interveners going first, then the applicant, and then the state. Please address your comments specifically to the Fall County ordinance. Bruce J.
Bruce Ellison, individual intervener. I only have one exhibit this time. This would be, it's incorporated BF, not GH. Thank you.
Can we just, I know we're not in a courtroom, can we just mark them all now?
That's the only one I've got.
Okay.
What? Okay. I'm sorry, C. Oh, thank you. That's an old one. Oh, okay. Thank you for the time it took to set that up. I made a copy of an ordinance that I know you are very well informed of, but again, I just wanted to have it in front of you as I talk about a couple of things.
Yes, sir.
This is a statute, not the ordinance.
I'm sorry, it is a statute. Did I say ordinance?
I thought you did. I thought we were talking about.
If I said the ordinance, I misspoke. This is STCL Exhibit
H, I believe.
H. Exhibit H is SDCL 456029, which has to do with the authority of this board to grant a permit in this uranium exploration permit application. What the statute does, as I believe you're aware, is this is your enabling statute. And this statute came about because of uranium mining exploration operations in Fall River County back 40 some odd years ago. And one of the things that this statute requires in its beginning part, it says, you know, it's entitled Grant of Permit if application is in compliance with the law. I'm not going to address 2 through 5 of the reasons that you can deny it, because 1, the application is incomplete, and we would submit that it is. And it's incomplete in part because of this ordinance, and would be in violation thereof to have submitted for your consideration to grant an exploration permit. And as it states, the Board of Minerals shall grant a permit to an operator if the application complies with the requirements of this chapter and all applicable local laws. Prior to CNAC making its application in this case, the people of Fall River County passed by referendum overwhelmingly an ordinance declaring that uranium operations were a nuisance and listed the reasons. That ordinance is the local law of Fall River County. Now, the applicants would have you believe that, well, let me back up just a little bit. One of the things that this statute does include about that local law requirement, that to show they are in compliance with, is different from the cases South Dakota Supreme Court's dealt with. It's a unique requirement in some ways. It's unique to this particular application or what this application is for. The passage of this, and I'll say it for the record, the passage of this ordinance caused a company that preceded CNAC to abandon its plans. So this company comes in and rather than, because they claim this ordinance doesn't apply, ignore it, because of the cases they cite having to do with not with uranium mining exploration permits. There's a reason why they want you to ignore it, because it's in there. And the thing that they should have done, and you can order them to do it, is, no, wait a minute. If you think that this statute doesn't apply and you don't have a Supreme Court decision on 456029 basically negating that part of the statute, they're asking this board to negate part of a statute that requires compliance with local law that existed prior to this application. There's one thing they could have done. They could have gone to a circuit court in Fall River County and asked for a declaratory judgment, maybe Pier. I don't know. I don't pretend to be a civil lawyer, so I don't know where the appropriate venue would be. But they could have asked for a declaratory judgment, and if they received a judgment in their favor, that this prior existing ordinance prior to the application, prior to them coming to you for an application, could show you that they were in compliance with all local laws. But they haven't done that. They're asking you as a board to negate the expressed will of the legislature that has not been amended since 1982. So we know that this ordinance passed. We know it was certified by the county. And I guess I want to make clear, the cases that in the Supreme Court, they involve generally where a county, there was a permit application pending, or a decision already been, permit already been issued, and the county tries to pass an ordinance that says, no, wait a minute, you can't do part of this. That's not what we have here. So they came to you and said, our application is complete, but don't worry about one of the 3 requirements that you obey local law and show that you are in obeyment of compliance with local law. What does that even mean then? If that statute is not the foundation upon which you must make your decision, then, I guess they're just asking you to just do what you want. So this is not an ex post facto enactment of a statute to stop what the state has authorized or is in the process of a pending matter. So in closing, I would respectfully request that this board overrule the lack of applicability of the local ordinance and ignore SDCL 45D29 requiring prior showing of compliance. Because one of the first things that the board can invalidate is if the application is incomplete, and I submit to you it is. But that's not the reason. I mean, that's the reason why it's incomplete. That's another reason to not allow it. You can grant summary judgment essentially on that. But it's because state laws require compliance. Thank you for your time. This is important in terms of what's important here. And what they're asking you to do beyond your authority, and they should go to court first because the statute's pretty clear. And it would be meaningless if a prior existing ordinance, local law, could be ignored. It doesn't say except when. Thank you.
Do you mind answering a question?
I will try, sir.
Lawyer to lawyer?
I'll try.
The ordinance talks about mining operations, not exploration permits, which was the basis for the ruling. Would you care to address that?
Sure. This is an effort to, I would submit, ignore the reality. And I'm sorry, I'm having what my mother called a senior moment. Could you please repeat your question?
Well, I think that the basis for the hearing chair's ruling was that the Fall River County ordinance declares mining operations to be a nuisance, not exploration.
Well, I think that that's one of the things that, I mean, you can't do uranium mining, and you don't do uranium mining unless you do uranium exploration. So it's like, which comes first, the chicken or the egg? And, if you want to deal with the, it doesn't make any sense to not include in operations things that are part of operations. They can say, no, it's not physically mining. I mean, one of the problems that this statute came about for was because Union Carbide put a 2,000-foot shaft into a nearby area that you could drive a truck into, and they called that exploration. So in reality, I mean, this company has, since it filed its application, expanded its lease holdings. It submitted proposals to the Forest Service. This is going to be a center of operations for a wider operation. So I would ask you to look at the reality of what a uranium operation means. You heard from the mayor, it includes exploration. The mayor of the city of the county where this ordinance was passed. That's what people were thinking. And now we're, you really can't. But look at what the will of the people is, and include this as a uranium operation. It's the only thing that in the real world that should be considered. Thank you.
Ben, we'll take you, and then I've been passed several notes that we're beyond time for a short break, so, all right, let's reconvene at 12:08. I would like to politely come back to order. If everybody could be seated, please. We're on item number 2. Dr. Ben, you're up.
Thank you, Mr. Chair. Before I move on to the remarks I had prepared, I want to draw attention to a distinction that you yourself very rightly made in your response to Mr. Ellison, which was you drew a distinction between mining operations and mining exploration, both of which fall under the more generic umbrella of mining or mining activities, which is what it says at the top of these mining applications. But you misquoted the ordinance. The ordinance doesn't use the word operations. The ordinance makes mining an unlawful nuisance. And as you rightly, in your own words, characterized, mining is the umbrella term that includes operations and exploration both. So I think we need to, check the transcript again, see the distinction that you drew, and then bear it in mind. Because the citizens of Fall River County did not say mining operations. They just said mining. And all mining activities fall under that umbrella term. Not to be too repetitive, because the rest of the remarks that I prepared, the first part of that has been adequately pointed out to you by Mr. Ellison. SDCL 4560-29 actively prohibits issuance of an exploration permit unless in compliance with all applicable local laws. It's uncontested that this is an applicable local law. Public ordinances become law the moment that they are enacted by a majority vote. The question of the distinction between operations versus exploration is actually not an issue, because they use the generic term mining. It doesn't specify. So in that context, that is an applicable local law. I would then turn to the argument by the DANR, which is that that the Supreme Court has, before I do that, I want to also point out that the Supreme Court has interpreted ordinance in light of their protective purpose, not rigidly by literal phrasing. This is in one of the legal submissions. It's already on the record, but the court case referenced is Welsh versus Centerville Township, 1999. And so that precedent would suggest that if there was ambiguity about whether mining includes both operations and exploration, that the protective intent of the voter is actually what the Supreme Court has very clearly privileged in its judgments in the past. And as Mr. Ellison pointed out, if there was ambiguity about interpreting the courts, the proper thing to do would be to go to the court and get clarity, instead of just presuming that the will of the people can be overruled. Now, referring to the submission of the DANR on this matter, the lawyer for the DANR cited a case whereby the legislature has this is quoting, the legislature has prohibited a county from declaring anything authorized by statute to be a nuisance. And the case that he quotes is Preserve French Creek Incorporated versus County of Custer. If you actually look at that judgment and the wording, which is expressly authorized, that precedent has no relevance to this case whatsoever. In Preserve French Creek Incorporated versus County of Custer, the county declared illegal, or a nuisance, a development that already existed and was already expressly authorized by state statute. The county attempted to overturn an existing statute about a particular location-specific fixture that already existed. This argument then that this somehow applies to uranium exploration because quoting again, uranium exploration is expressly authorized by state law. Well, no. Uranium exploration is a generic category of activity that might occur in some locations and not in others. To say that because uranium exploration is expressly authorized by state law, therefore no county can regulate location-specific permissibility of uranium exploration. I mean, consider the precedent. We've got hog farming in South Dakota. It's not illegal because there are statutes that say that hog farming can be authorized. By this logic, the fact that there are statutes that in a generic sense say that hog farms can be authorized, every hog farm application in every location is immediately exempted from local control. That's not the way the law works. You're making a mockery of the term expressly authorized. Expressly authorized means a particular development, not a whole category of future proposals that could land in any location. And I mean, frankly, I'm kind of embarrassed that my tax dollars paid for that legal judgment. It's ridiculous. Furthermore, even if the Supreme Court were to revisit this question and say, actually, mining does not include mining exploration, which would absolutely require a Supreme Court judgment in this case, and we are not the Supreme Court. But even if they did, to preclude evidence of this public referendum is to preclude evidence that this board is required to consider, because under the other statute, which I could quote at you, but I'm sure you know it, you are required to weigh the adverse effects of this activity against the benefits. Even if this wasn't a law at all, even if this was just a public poll that was verified where somebody went door to door in Fall River County and said, do you think it's a good idea for us to have uranium mining? That's evidence of the will of the people. It's the evidence that you absolutely need when you do your cost-benefit analysis. Otherwise, what are you doing? It appears that not you, but Chairman Morris is trying to prevent evidence of the will of the people from being used in a cost-benefit analysis. Who better than the affected people know whether that cost to their lives is worth the risk? The benefit to their lives is worth the risk. I would also point out that the benefit isn't to anybody in Fall River County. The benefit are to Chinese shareholders in a Canadian shell company.
Mr. Chairman, bring it around.
Okay.
Yes, sir. Yeah, can we?
Okay. So
we're not talking about everything else. We're talking about an ordinance.
Yep.
Period.
Okay.
Period.
And the ordinance is the only clearest evidence of the will of the citizens of Fall River County. Even if it was just an opinion poll, you would have no legal basis to exclude it because you are required to do a cost-benefit analysis. That's all.
Thank you. Any other interveners that wish to appear on item 2?
Yes, this is Sarah Peterson again.
Yes, please proceed.
Thank you. I have lived in Fall River County for the last 24 years, and it was in 2012 I found out about the uranium that had gone on in this county and the uranium that was being proposed, the mining. And in November 2022, the people of Fall River County spoke. We did not want any more uranium mining in our county, and nobody was listening to us. So we started a ballot initiative to make uranium mining a nuisance in Fall River County, and that's how it's listed on the ballot. Nuisance is from the Old English law stating an activity causing a substantial interference of the land, the use, and the enjoyment of it impossible. Statute 7-18A-14, the majority of the votes to approve an initiated measure effective date. No ordinance or resolution is effective unless approved by the majority of the voters and cast for and against the ordinance or resolution. If approved, the ordinance or resolution is effective the day following the completion of the canvass and the election returns. The vote was on 1,993 for the initiative and 1,537 against the initiative. We won by 12%. That's substantial. We, the people, do not want uranium mining in our county, and once again, you have not heard our voices. And here are some of the reasons why we don't want uranium mining in Fall River County. There are already 7,500 exploration boreholes that have never been plugged in the Dewey Burdock area. The exploration drilling creates holes connecting all the aquifers, which spread contamination. And the open exploration boreholes contaminate not only the aquifers, but the ground, the water, the air, and the land. The legacy open pit Darrell mine is full of radioactive water. Radionucleotides have moved from the legacy mine down 2 creeks below and into the Cheyenne River.
Ma'am, this is the chairman. Could we focus solely on the ordinance?
Well, this is why we did the ordinance. These are the things the historic reasons why we don't want any uranium mining in our county.
I understand that, but item number 2 is the effect of the ordinance, whether it's applicable to this situation or not, and that's what I would like to discuss.
Well, we won by 12 points, and I don't know why it wouldn't be applicable, because if you're going to do uranium exploration, what's the next step?
Thank you. Do you have anything else to add?
No.
Thank you. You'll have to state your name again, and you did a great job last time staying in the bumpers.
Oh, I hope I can this time.
Parameters. Well, I figure these, I feel they are the parameters, because this is why we went to all the trouble. It was a lot of work to get that, ordinance completed.
Thank you.
And it's not being, okay.
You'll have to state your name again, just so we get the transcript right.
Okay.
Okay. It's Sarah Peterson.
All right, thank you.
Got it. I'm Elizabeth
You're welcome.
Lonigal, and I'm a pro se intervener. And before I get into my statement, I want to apologize to the board for the language I used when I was walking away. I believe the sentiment was appropriate, but I apologize for the language that I used. And with that, I'd like to get directly to what I believe is at the heart of this matter, especially directly related to this ordinance. And that is that this application by CNIC, EXNI 453, is being used as a tool by CNIC and other corporations in the industry to use corporate force to undermine the will of the people. They're looking for a way to get that ordinance overturned, and they're using this as the tool. And that is why this ordinance needs to be followed by the board. Thank you.
Thank you. Okay, any other interveners that care to address issue 2? Mr. Mayor, we'll get to you. You need to turn your mic on, ma'am.
How's that?
Better.
Okay, Karen Lerman, individual intervener from Hot Springs. So in August 11th, 2022, the citizens voted declaring uranium mining an unlawful nuisance in Fall River County. And I worked with Sarah and I, collected signatures. And as I mentioned before, a lot of people in our county, in our city, are very concerned with this issue. That's why we did the ordinance. Appointed Chairman Morris deemed our legal ordinance based on the justification that this is a mining exploration, not mining. Mining exploration has the intent to mine. Why else would they be doing it? If mining's not allowed, yeah, I already said that. Why would they be proceeding? There would not be this application if they don't intend to potentially mine in the future. Mining exploration includes A, development and construction, building roads, bringing mining shafts, bringing in heavy equipment, rigs to collect core samples and analyze depth, quality, and quantity. B, stripping, drilling, blasting. So the damage with this exploratory permit is already happening. It's already happening to the wildlife, to the cultural resources, and to the land. So the exploration is a high risk for a very low revenue. There's not even, assurances that they're gonna receive and get what they're looking for. And what is the cost? It's too large of a cost to take that risk. Thank you.
Thank you. Mr. Mayor, you've been waiting patiently. If you care to come forward.
Bob Nelson, Mayor, City of Hot Springs. So I'll trust that if I get off track here, you folks will steer me back. So,
yes.
As correctly noted in Chairman Morris's order dated December 22nd, 2025, the citizens of Fall River County voted on August 11th, 2022 to declare that uranium mining is an unlawful nuisance in Fall River County. The basis for Chairman Morris's decision that the ordinance is not applicable is that mining exploration and uranium mining are legally defined as separate activities, and the local ordinance only refers to uranium mining. I acknowledge that strict legal distinction exists. However, it's my understanding that there are legal precedents from South Dakota Supreme Court whereby local ordinances are interpreted liberally with reference to their protective intent, not their narrow legal definition. Interpreting legal precedents is the job of the courts. It seems improper to prevent the hearing from considering evidence of the will of the people. The Minerals Board will be charged with weighing the benefits of this application against its costs or risks. But there are no benefits unless and until the project proceeds to commercial mining. Therefore, a cost-benefit analysis is only possible by extending the discussion to include the full commercial mining phase. The results of a public referendum provide the clearest evidence that in the minds of the affected citizens, the cost of this proposal are greater than the benefits. I can imagine no defensible argument whereby the will of the citizens can be excluded from a public hearing to weigh the costs and benefits of any proposed development. I thank you for your consideration of this submission in this matter, and I'll sum up by saying I am not a subject matter expert in uranium exploration or mining. Don't have a clue. My participation today is to advocate for the process that I've seen happening this morning. You listening to the affected people of the decision that you made today. And I want to personally thank you on behalf of the citizens of Hot Springs and myself for recognizing that the majority of the folks want to change the venue, and you did that. Thank you very much. As I was driving down here, I wondered if what I was going to say would be appropriate, if it'd be enough, it would be too much. And what came to mind for me is the motto of the state of South Dakota: under God, the people rule. And in my mind, the decision that this board made today goes very deeply into recognizing the will of the people. They spoke, you heard them. So thank you for that. You upheld our motto. It's important to all of us. Thank you.
Thank you. Did we get your letter in? Bruce, did we get his letter in?
Yeah, I believe Ben gave him a copy.
All right, thank you.
Thank you.
Any other intervener to be heard?
Hello, Taylor Gunhammer here. I want to say that I went downstairs and went through the security checkpoint again, so I hope Mr. Nas feels safe. I don't normally entertain people's open racism, but I
You're
feel
out of
generous
order.
today.
You're out of order. Address item number 2.
Mr. Chairman,
the
if that
affected
happens
ordinance.
again, I'd ask that he not be recognized. Thank you.
I'm going to let you continue on only item number 2.
Oh, thanks. Okay. So, under South Dakota 29, South Dakota Uranium Exploration Act, though it has been the board's contention that they cannot deny this permit, there actually are reasons that they can. And one of them is if the adverse effects of a proposed uranium mining operation on historic, archaeologic, geologic, scientific, or recreational aspects of affected or surrounding land outweigh the benefits of the proposed exploration project. And here, you have threats to every single one of those. And the Fall River County Ordinance, the stated voting will of the people, is proof of that. It's relevant. And so, unfortunately, in my opinion, rather embarrassingly, what the board has decided to date, thanks to Mr. Morris, is that the will of the people is irrelevant so long as a foreign mining company desires to profit from the land where those people live. It's an absolute travesty, and for you to casually dismiss the will of the people, so casually as Mr. Morris did, is a miscarriage of justice and a failure of the oath. I assume you all took, did you all take an oath?
Beyond the scope. That's beyond the scope of item number 2.
This, whether or not you took an oath to uphold the Constitution is outside the scope of this?
Excuse me, Mr. Chairman.
Yeah, Doyle.
Yes, let's, like it says, we don't need an editorial or opinions. We just need the facts. Thank you.
Do you have anything further to add?
Yeah, everything I said was facts. That all happened. You can check the record, including Mr. Morris calling me a jerk over and over. And I am
Again,
not
that's
of
beyond
the
the scope
belief
of
that a
item number
Canadian
2,
mining
Mr.
company has
Gunn.
more rights than
if
Fall
you-
River County, the city of Hot Springs, all of the affected tribes whose treaty land this is.
All right,
That's
I,
Thank you.
we're done. We're done here. We're done with this witness. Not done here. Any other interveners that care to address item number 2? If not, we will go with the, oh, I'm sorry. Yes, ma'am.
Okay. Okay, hi. My name is Susan Pang, and I'm an intervener. And we have property on Cascade Road, which is in the Whitney Preserve, which is owned by the Nature Conservancy. It's about 5,000 acres, and the largest natural spring in the Black Hills is there. And it is called Cascade Springs. And actually, there's a group of us every summer. We actually go swimming in all the creeks and in all the ponds and all that. So there's a real beautiful place. If you guys ever want to explore and go hiking, just call me. But anyway, regarding number 2, Sarah Peterson, who you heard, I met her for the first time at a tribal summit that in 2024 that addressed water issues, and she gave a talk for about 15 or 20 minutes describing the procedures that she went through to get the ordinance on the ballot. And I was just flabbergasted by her energy and the time that she had spent to do that, and I was really appreciative because all I really had to do, my husband and I, was vote. But even just going to vote on that ordinance meant that we had to leave a family reunion and make sacrifices to get our vote in, because to be honest with you, that was the only thing on the ballot that really mattered to me. I was voting not for anything else but that. That's all I cared about. And also my husband. And so, I mean, water is the most valuable resource that we have, and there's places all over the planet that are wishing they had the choice to make the decision that you're making today over again, because things just didn't go the way that people had planned. And
Sharon,
yes,
could I please interpose an objection as to relevance as to item number 2?
I will.
Sir, can I have a moment to talk? I drove all the way here in 3 hours. Shut up.
We don't.
Yeah, we don't, but let me finish. I didn't even get to finish
It's
my...
up to me. Just relax, okay?
Yeah.
I am not going to, I'm going to overrule the objection, and I will direct you, look at me.
Yes.
To please limit your testimony to
What
item
haven't
number 2.
what did I say that was objectionable, please?
Well, we're all over the board. The purpose of the hearing
Well, no, but
isn't
I came here
evidentiary.
this morning. I drove here for 3 hours.
I understand that,
To come
and
talk, and I don't know. This guy has had plenty of time to talk. He's had more opportunities probably than anyone in this
Mr.
room.
Chairman, we
and then
gotta-
I cannot finish my sentence.
That's gotta end, or
The point is, ma'am.
Okay, but I was talking
stop
about the
speaking.
ballot
Stop
and the
speaking.
ordinance.
I understand. Stop speaking for one moment. What we want you to focus on is item number 2 on the agenda.
Yes.
And your arguments as to why the hearing chair's ruling was incorrect. That would be supported by some point of law or some point of fact, and that's fine.
Well, it's the intention.
The objection is already
It's
overruled.
ludicrous.
Ma'am, just wait. Okay, take a deep breath, and you can continue, but you have to continue on point. Okay, this is it's just not all over the place. Focus on the issue that's before the board and present, and that's 100% fine.
All right. Do we need a minute, or are you ready to go?
Well, okay. I mean, really, I only came here to talk for 2 minutes. Okay, I sacrificed a whole day.
And we're thankful.
And so
we're thankful that
that's
you
all I'm
did.
here for. And I don't have a political agenda. I'm not making money from this. As a matter of fact, I sacrificed a lot of things today that I could have been doing better than coming here. Okay, so I think I just would request that this gentleman over here just lets me talk. Okay, I'm only here going to talk for less than 5 minutes.
We're ready for you to talk.
Okay, so anyway, Sarah went through a lot of trouble to get this on the ordinance, and we left our family reunion to come and vote. And then I hear all of a sudden about this intervention and all this stuff that's going on, and I received this is in my mailbox for all the bullshit. I'm sorry, that's just what it is. For something that I already voted on. So what is this? Okay, I have to open all these envelopes and realize we live in Hot Springs. It's a place that's honored for water. Moccasin Springs, Evans Plunge, all the creeks and stuff. It's the most important resource that we have anywhere on the planet, but especially in Hot Springs. And then after all that, I'm part of this circle of letters and mailings and bullshit just to say, hey, the people here, all the people here, whatever color skin they have, however long and generationally long they've been here, thousands of years or hundreds of years or 2 years, water is the most precious resource we have. Hot Springs is known for its water. Please honor our request when we voted on that ordinance and do the people right, because the intention of exploratory drilling is to drill, okay? We're not stupid, okay? And it's an insult to all of our intelligence that could even be suggested. Thank you.
Thank you. Any other interveners that wish to appear on item number 2? Yes, ma'am.
You guys want this pile? This
No,
is my
thank you.
documentary evidence here.
Hi, my name is Jean Roach. I'm an intervener. But I just had a couple points that I wanted to point out. And one is when you Google expiration, this is what it says. Expiration is considered a vital first phase of the mining life cycle. So we need to, not try to reword this ordinance where mining's a nuisance, and there's clear reasons why it's considered a nuisance. And one of them is that the previous 700 exploration holes have never been even cleaned up. So I think that's just a couple points I wanted to mention. Thank you.
Thank you. Any on the, can't talk, any other interveners?
Yes, this is Sarah Peterson again.
Hang on, we have somebody that's at the podium, ma'am. Go ahead.
Okay.
There you go.
Marla Cooley, Hot Springs. I have the work that Sarah Peterson did right here for everyone. This is following up with what Bruce Ellison gave us, the mandate. And this just shows all the signatures and all the work that's been done. It is not something that's been in the record, but this is what our
If we could hold on for just 1 second, before you hand that out to the board, are there any objections?
Foundation, honestly, I've not seen this before. I don't know where it came from or where these numbers came from, so with that, I would interpose a foundation objection.
I need to see them before I can do anything.
Yeah, you can hand a copy to the board chair to review.
Perhaps it could be marked for the record as at least for identification of the...
I've seen these. I've seen this.
Oh, that's the voter rolls. Yeah, those are part of the record.
Yeah, these are all part of the record, ma'am.
So I can distribute for
You can
today's
distribute,
hearing?
yes.
Excuse me, Mr. Chair, I believe they need an exhibit number.
Pardon me, Bruce, I didn't
I
hear.
believe they need an exhibit number.
Yeah, we'll mark them.
Very good, thank you.
You've copied the court reporter?
Yeah.
To mark it?
Over here. Are you doing the certificate first? Okay. Yeah, let's just make it all one exhibit.
Yes, I brought that because Ms. Peterson was ill this morning, and I would like to hand it out on her behalf. She's done the work. That's why I present that to you. I also, following the person just before me, exploration, the goal is to get the foot in the door. After that, we're going to sell our stocks and make a lot of money, because we are intending to mine. Why would we go to the expense, a company, any company, to that great of an expense to bring in all the equipment and build roads to not do anything but just explore? That's idiotic for us to try to stomach and swallow that. And we have investments here. Our community has people who love the community. I'm a server and worker right there in Hot Springs in one of our restaurants, and I talk to a lot of people. No one wants this. We want healthy, safe environment, which is your job. You took the oath to protect our environment for families and people and opportunities for business. And I would ask you to please listen to the heart and the words and the voice of Fall River County. Thank you.
Thank you. Now we had somebody, Roberta, online.
I believe it was Sarah Peterson who wanted to speak
Okay, is she available?
Yes, I am. I didn't get to complete my, all I was talking about with the ordinance, and I just wanted to give you my conclusion, my ending to all of what has happened here, as far as devastation to our community. Please honor our ordinance. We, the people, have spoken, campaigned hard, and voted for this ordinance to save our quality of life in stewardship for future generations. Thank you.
Thank you. Any other interveners? Yes, ma'am.
Is this on? Yeah. Denise Gallego, individual intervener. I just wanted to mention, I believe on the Forest Service application for exploration, it is categorized as mining activity. So even the Forest Service does consider exploration an aspect of mining. It seems pretty obvious, but since there's a bit of debate about that. And I believe the company, Nexus, has purchased over 6,000 acres in that area.
Mr. Chairman, we got to get back to the ordinance, otherwise
that.
we're going to be here for 2 days.
Okay, well, I would just simply suggest that that doesn't sound like an exploration, solely an exploration project. And I'll finish there, thank you.
Thank you. Any other interveners? Applicant.
Thank you, Mr. Chairman, members of the commission. The order regarding the Fall River County mining ordinance was based on the fact that there are two entirely separate chapters of South Dakota codified law dealing with exploration, uranium exploration activities, and mining operations. The definition of uranium exploration activity includes before commencement of development or extraction operations and test facilities. Exploration occurs well in advance of any mining activity. The reality is that between 1 in 5,000 and 1 in 10,000 exploration projects move forward into development. And that's why in our code they are addressed differently. 45.6D controls uranium exploration. 45.6B will control mining should this project or any project develop that far. Should that happen, any applicant would have to come back before this board and have the criteria identified in 45-6B addressed by this board. At this time, however, it is the exploration, not the mining, that this board is being asked to consider, whereas the Fall River County ordinance speaks directly to mining. It's important to know a little bit about the exploration activity we're talking about here. Nexus Clean Nuclear Energy proposes to drill 38 holes on Section 36 in Fall River County, state-owned land, to look for uranium, to find out if there's any uranium there, to see what is there. It is certainly cart before horse to suggest that mining could occur before we even know whether or not uranium exists there. These 38 holes that will be drilled at this location will be relatively the size of water well holes. And the process includes, as you well know, DANR watching to make sure that those holes are plugged and reclaimed appropriately. There's been some conversation regarding existing holes that weren't perhaps plugged correctly. This won't happen here. DANR will be watching. DANR will make sure that this is...
Mr. Nas, if you'd hold for one moment. The people in the audience have to, remain silent during another person's testimony. You were all afforded the courtesy of having the microphone without interruption. And it would be appropriate to extend that same courtesy, and continued disruption will result in your exclusion from the room.
Continue.
Thank you. These exploration holes will be done appropriately with modern techniques, safely ensuring no harm to water, to the land itself. Reclamation bonds will be in place to ensure that. DANR will be watching the process of the drilling and the plugging to make sure that that is done correctly. But make so...
Overruled.
But make no mistake, it's exploration, not mining. The ordinance itself addresses mining, not exploration. This is an exploration permit application, not a mining license application. Therefore, the uranium mining ordinance adopted by Fall River County is irrelevant to these proceedings. Additionally, as our Supreme Court has stated very recently in the Preserve French Creek decision that has been identified in the briefings on this matter, the mining ordinance would be preempted by state law pursuant to SDCL 21-10-2. It would be a permitted activity, and would be a permitted activity, sorry, and therefore cannot by law, by statute, be a nuisance. The hearing chairman's decision on this issue is correct, and we ask that it be affirmed. Exploration is governed under 45-6D, mining under 45-6B. Those are two different things. This is an exploration permit application, not a mining permit application, and we respectfully request this commission affirm the decision of the hearing chair. Thank you.
Thank you. Mr. Blair.
Mr. Chairman, Steve Blair, General Counsel for DANR. I think it's important to start with, when you look at this ordinance, you review local ordinances the same way you do statutes, and this board, through its quasi-judicial authority, is authorized to review statutory language, and that includes ordinances. You look at the plain language of the ordinance, and the ordinance says mining. It doesn't say mining operations, it doesn't say mining exploration, it doesn't say exploration activities, it says mining. As Mr. Nas indicated, argued, and the department agrees, those are covered under two separate chapters under state law. And so the ordinance in the department's position, and we filed a brief on this, is not applicable to an exploration application because of that reason, the very plain language of the ordinance. If you were to determine that the ordinance, the use of the word mining was broad enough to consider the language or the actual ordinance itself, I would join in the argument the ordinance is preempted by state law. And this goes to the board's quasi-judicial authority to determine under the statute what is applicable. And so if you determine, well, the language of the ordinance may lend itself towards applicability, I think you're still authorized to make a determination whether the ordinance is preempted or not. And I would argue that under the Preserve French Creek decision and other decisions regarding preemption, that the ordinance would be preempted. You cannot declare a nuisance something that is expressly authorized by state law. And mineral exploration, uranium exploration, is expressly authorized by state law. And so for those two reasons, the ordinance is not applicable to this proceeding, and would ask you to uphold the decision of the hearing chair. Thank you.
Thank you. Any responses?
Just a brief response. Thank you, Mr. Chair. Bruce Ellison, individual intervener. I just heard a bunch of somewhat conflicting things, but I appreciate the state recognizing that if we have a valid ordinance that applies, that it may be dispositive. And that's what, in fact, I think we have here. But I heard a lot of arguments about it can't be a nuisance for this reason. That goes to the merits of whether it's a nuisance. That would go if you decided it does apply. We can hear evidence and arguments about those particular things. Mr. Nas pointed out that exploration is prior to development. If we look at the application in this case, it's 50 holes drilled on state land. That's more than on the federal lands. They're mapping the edge of that formation that they know exists, the Biancara, that contains the uranium. There's no question but there's uranium in those folds. That's not the issue. The issue, I mean, look at how deep they're going. Look at where they're going. And we can get to that. I look forward to it if we have to go forward on the merits or whenever we do, to talking about the status of that land, the stratas that are in there and the porous nature of them and the interconnecting hydrology. We have very unique hydrogeology in the Black Hills because we're an upthrusting. It's all over the place. But one thing we do know is the Biancara in that area contains uranium.
We're talking about the admissibility of
Yes,
the
sir.
ordinance.
Yes.
Let's stay on
Thank you.
topic.
Thank you for bringing it back. This is, you know, I appreciate the state pointing out some of the authority that you do have in terms of interpreting statutes or ordinances or regulations. But the French Creek case doesn't talk about the local law requirement that's in the statute that enables the issuance of the permit, as opposed to a later effort to stop an ongoing operation or an approved operation or a pending operation. And just to remind you, as pointed out before about the hog farms, just because the state is authorized to issue permits for confined animal units, as destructive as they are, that's a different statute, enabling statute, than this one. And no local law would be possible to be implicated. That statute becomes meaningless, and you're enabling statute. So please, local law means something. It should mean something. It's there for a very specific reason, because it's about what do the local people in the affected areas need. And therefore, I would submit that you should declare that the ordinance is valid, and that once CNEC has obtained a circuit court order that to the contrary, that they can then come back, or that's just simply invalid and they can choose what they want. But please don't rewrite state law. Thank you.
Jay Davis, individual intervener. I would contend that part of the relevance of the Fall River County initiated ordinance is that it gives Mr. Blair a legal and ethical obligation to oppose the proposed exploration permit, because his clients are the people of South Dakota. And we don't need to speculate about what his clients want him to do in this matter, since the voters of the relevant county spoke and by a decisive margin declared uranium mining, including exploration activities, a nuisance. Therefore, I believe he's bound to respect and follow that verdict from his clients. Thank you.
Thank you. Anything further?
Literally only 1 minute less. I just want to reiterate that I think the term expressly authorized is being badly misquoted and badly abused here. Expressly authorized can't possibly refer to an entire category of activities that the government has jurisdiction over. That would include everything. Expressly authorized refers to a particular development in a particular location, which is what the French Creek precedent referred to. That precedent is being very badly cited, and I think that the term expressly authorized cannot possibly mean what he says it means. Thanks.
Thank you.
Elizabeth Lonigal, pro se intervener. With regard to what Mr. Blair stated to the board along with CNEC's other attorney, I believe that everything that they stated proved the point that I made earlier, that this is an attempt through CNEC's application to use corporate force, and I mean force, to undermine the will of the people.
Thank you. Anyone else? So we're once again faced with making a decision on the ruling number 2. And the choices are to approve of Mr. Morris's ruling, or not to approve of his ruling, or to revise his ruling. Are there any motions?
Mr. Chair,
Yes, Rhett.
I would make a motion to uphold Chairman Morris's decision that the Falls River ordinance does not apply to the ENXI permit.
I'll second the motion, Ewing.
There is a motion and a second. Is there board discussion?
Yes, this is Chairman Blumhart. I would really like to, I think in a lot of ways I would really like to have some clarification from the courts on this. I'm getting the impression that we don't know exactly where we're at with that local ordinance. I just have some reservations about moving forward with the whole thing until we would have clarification from the court.
Sorry, Glenn. Greg, we have a motion and a second. We can allow, however, a substitute motion for the current motion upon motion and second. Are you suggesting, Glenn, a substitute motion?
I guess I'm having angst with the way this whole thing is going as to the validity of that ordinance and stuff without clarification from the court. I guess that's my issue with the whole thing. I don't know how other board members feel about it. I'm just stating my feeling with it.
But you're not providing a substitute motion.
Okay, I will provide a substitute motion. I would provide a substitute motion that we put these proceedings on hold until we get clarification from the court as to the validity and how the reach of that Fall River ordinance. Because if it goes to court eventually, which it probably will, this all could be for naught because of the ordinance. And I would like clarification. So I would say we would put this on hold and have them go to court and get some kind of clarification from us for us on this ordinance.
Grunwald seconds.
There is a motion and a second. Is there further discussion amongst the board?
This is Board Member Rhett Miller.
Yes, sir.
I guess as far as clarification goes, I somewhat agree with Glenn on that, but the Falls River ordinance clearly states mining, and that this is a exploration permit, and we've been carrying this on for far too long, and we need to move forward and render a decision one way or another on it. So, as the state has already stated, we do have a quasi authority to force a decision in that matter. So I guess I would propose that we decline the motion and move forward with the original motion on the table and vote on this.
Any further discussion?
Carpin, I have to agree with Mr. Miller.
We will then, any further discussion amongst the board members? So what we will call the question on is the subsequent motion that has been made and seconded. That motion being to not continue the hearing until such time as we receive clarification on the effect of the ordinance. Any further discussion? Brenda, call the roll, please.
Ewing?
No.
Grunwald?
Yes.
Egg?
Yes.
Carpin?
No.
Miller?
No.
Morris?
Point of order, Mr. Chair.
Yes, sir, Mr. Morris.
The substitute motion appears to be outside the scope of the particular issue concerning my ruling. So am I able to vote, or must I continue to abstain?
If I were you, I would abstain.
I'll abstain then.
Schultz?
No.
Blumhard?
What did you say?
Yes.
Lori, did you vote no?
No. Yes. I voted no.
Thank you. And Blumhard?
Yes.
Greenfield?
No.
Five noes, four yes, no.
Three yes.
And one abstention.
Motion fails. We're back to the original motion, which is Mr. Miller's motion to uphold the ruling of the hearing chair. Any further discussion? I heard Mr. Carpin say that he called the question.
Yes.
Is there a second for calling the question? Brenda, call the roll on the original motion, which was to uphold Mr. Morris's ruling.
Ewing?
Aye.
Grunwald?
No.
Haig?
No.
Carpin?
Aye.
Miller?
Aye.
Morris abstain?
Yes, abstain.
Schultz?
Aye.
And Blumhart?
No.
Greenfield?
Aye.
Okay. 1, 2, 3. 5 yes, 3 no, 1 abstain.
Item number 3, applicant's motion in limine to preclude evidence regarding mining. Interveners.
Good afternoon, I guess it is now. This is Dr. Lilia Starding. I'm an intervener. And I told you I would sort of talk about who I was a little more. I live in Rapid City, and I have worked on mining issues in some form, including uranium mining issues for pushing 50 years. I have a PhD in environmental policy, or specifically it's political science PhD with a specialty in environmental policy. So I have dealt with these issues for quite a while. I am opposed to applicant's motion. I am mainly in that situation because mining includes exploration, but there is a spectrum in terms of mining activities. While people try to divide it into different sectors of activities, it all ends up going to mining. So the experience that I have on this particular issue is that the line between mining and other things, as has been talked about, is vague and unclear. And I have an experience from some years ago, and this has been mentioned in passing, but there was a company that wanted to apply to the state and wanted to explore for uranium right in Craven Canyon, the area we are talking about. And this was in 1979. And what happened was the company actually started mining. And so that makes me mistrust the holding firm on that line, okay? I mistrust, not specific companies besides Union Carbide, but I sort of mistrust the mining industry after that experience. That case went all the way to the South Dakota Supreme Court, in which it was decided in against the company, okay? And in the eventual hearing, I have a copy of that decision. So if we only talk about the word mining and exclude other things, that clearly excludes relevant information on past exploration and mining impacts on the current proposed site. And it also excludes the eventual goal here, which is for the company that they want to mine. Past activity is important. And if people can't talk about past activity because it is somehow becomes categorized as mining separate from exploration, we would be unable to talk about things like what have the water impacts been underground at this site, because they would be from past activity. The statute that we are working on here is SDCL 45-6D29, and under that there are several bases upon which the board may deny a uranium exploration permit. One of that is actually includes past exploration and mining impacts on the area, because one of the things that can exclude the issuance of a permit is that it would cause adverse effects to historic, archaeological, geologic, scientific, or recreation resources, okay? All of those could be present, depending on how this project played out. There's also the situation about potential impacts on wildlife, water, the landscape, those kinds of things. So again, this is something that in some form I think will come up during the full hearing. But for this, at this point, I want to oppose the applicant's motion and suggest that, or request that Chairman Morris's order be overturned. Thank you.
Thank you for your concise summary. Anyone else, an intervener that desires to be heard on item number 3? Dr. Ben.
It's Dr. Sharp.
Dr. Sharp.
Thank you. Okay, I'm going to make 3 separate arguments here. First, I would point out that South Dakota Codified Law 45-60-29, subparagraph 3, requires that the adverse effects of the proposal is weighed against its benefits. Now, I understand that we hear a lot of very fine parsing of the precision of the language, and we have to stick within the language of the way this is written. And it might be uncomfortable to recognize that this law is badly written. But I'll submit, if you want to actually follow this law as it's written, the adverse effects of the proposed uranium exploration operation outweigh the benefits of the proposed uranium exploration operation. If we limit the consideration to the exploration operation only, the benefits are zero. There is no benefit of exploring unless you proceed to talking about what are you going to get back if you're commercially mined. Nobody disputes that. So unless we're going to adopt a very slippery, sloppy process where sometimes we're being very strict and we're talking only about the exploration phase, but then once we start talking about the benefits, we slide into talking about the benefits of the entire, commercial operation cycle. The decision's already made. The benefits of the exploration phase are zero if it doesn't proceed. So in order for you to faithfully deliver the requirements of SDCL 45-60-29, by definition, you have to consider either only the exploration phase, in which case the benefits are zero, or you consider the entire phase, in which case you have to consider the costs and the benefits of the same time frame, the same operational cycle. You can't have it both ways. So the cost-benefit analysis, by definition, has to be of the entire process, which means you need evidence of the entire process. On to a more legal argument. South Dakota Supreme Court, and this is in submissions that have already been submitted to you, has adopted what they call a lenient standard of evidence. That's a direct quote. And this standard, again, direct quote, permits evidence to be admitted even if it only slightly affects the trier's assessment of the probability of the matter to be proved. And then another quote, the law favors admitting relevant evidence no matter how slight its probative value. That's from State versus Bowker, 2008. And this lenient standard of evidence has been upheld again in Connect versus Everidge, 2020, and State versus Hankins, 2022. So it's not it's not ambiguous whether or not relevance is defined incredibly narrowly or incredibly widely. Quoting from this submission that was sent to you by the tribes, it is sufficient that the evidence has a tendency to make a consequential fact even the least bit more probable or less probable than it would be without the evidence. So to say that, I mean, we've already heard that the term mining is awfully broad. It includes exploration, it includes operations. We've also heard that there's a lot of impacts in the exploration stage, including erodes and disturbance and drilling. To say that you're going to preclude evidence of mining will include pretty much everything, any piece of evidence anybody wants to submit. I can imagine no basis, no honorable basis for passing something so vaguely and poorly worded. And I would encourage you to actually go back and look at the transcript from January 6th, because we pointed this out. The argument that we heard, and the argument that you will hear when CNEC has a chance to talk, is that, well, in this process, we're only talking about the impacts of the exploration phase. And we said on January 6th, if that's actually what you intend, say that. Say, we will be focusing the evidentiary process on evidence of impacts of the exploration phase. But if you pass a motion that says preclude evidence of mining, that means any evidence derived from mining, which means evidence of how water moves through fractured geology when you put polluted water down a hole. Well, that's what you do during the exploration process too. So evidence derived from mining of the impacts of the exploration phase will be ruled inadmissible because it came from from evidence elsewhere where there was mining occurring. It could also include evidence of previous mining. So the fact that there are abandoned boreholes or abandoned tailings or abandoned operations from previous mining in the area, is now out of scope because it's evidence of mining. It's evidence of the geological setting in which you are operating. If there's boreholes connecting the aquifers, allowing your water to leak as soon as you put it under pressure, that's physical evidence. Under this really poorly worded motion, that's precluded too. Physical evidence of the actual geology is being precluded. And we pointed that out. Read the transcript on January 6th. We pointed out this is a really sloppy wording, even for your own stated intention, because you're creating a loophole that you can drive a truck through. The response was, and I directly quote this, although you can actually check the transcript. Your objection is noted, please sit down. Really? Evidence is evidence. I'm a scientist. Evidence is derived from a lot of different sources, and you apply it logically to the question being asked. If the actual intent was to limit the question to we're only talking about the impacts of the exploration phase, he could have worded it that way. Instead, he created a loophole big enough to drive all kinds of atrocities through. And I think that if you let that go, it looks deliberate. And the citizens are watching, and nobody appreciates it because you're treating us like we're stupid because we can't see you building loopholes as you build them. Maybe that's not the rest of your intention, but this is your chance to show that. Thanks.
I have a question, Dr. Sharp. How would you reword the motion?
Well, first, you would have to say, how are you going to deliver an analysis of the cost versus the benefits of an operation where the benefits don't accrue at all until it extends to commercial mining? So in that phase, it's just not possible because there are no benefits, and we wouldn't be here. However, if during a portion of the proceedings you wanted to limit the scope, you would say, evidence relevant to consideration of likely impacts of this operation in the exploration phase. But I provided that on January 6th, and I was told to sit down. So it doesn't feel like anybody actually wanted to be practical. But I would love for you guys to prove me wrong.
Bruce, thank you.
I certainly share Dr. Sharp's remarks. Again, we're asking about how do we deal with this thing in the real world. I would propose, Mr. Temporary Chair, that a motion that would overrule the hearing chairman's ruling, and that the board decide that, similar to what Mr. Sharp said, but perhaps approaching it in a different way, that the board hold in abeyance a decision because of the issues of what do we define mining or not, or something that is relevant even if it strays into a technical aspect of mining. So that basically, in an effort to show why the permit should be denied, that as an issue comes up, the board could then decide it rather than doing a carte blanche elimination of a poorly defined term. And then you could really weigh whether there's a relevance to an issue that is under your consideration, even if there might be an aspect of it that also strays into what might otherwise be considered part of a mining operation. So I'm giving you guys a break for today. I'm just basically saying let's do it when it's something, a time that you could really determine it. Because right now you're making a decision in a vacuum of context. And I'm not going to say that's going to be an easy decision and trying to draw where those lines are. I mean, this area is a mess. And how do you decide what the impacts are going to be of this particular project unless you include everything that's happened around it that could be connected by hydrology or other means. So, and so that's in addition to the fact that, you know, this is an area that is no question but that there is uranium, and there are lots of holes in there, and there is a known, generally, you know, they're trying to see exactly, they want to map the highest grade areas of where this is. That's what the holes specifically are for the state lands. But the only, outside of these hearings, CNEC talks like it's got, you know, it's seeking investors for its operations, for its mining operations, for its milling operations, to become the hub for processing of uranium ore into, you know, into yellowcake to ship it to Canada for enrichment. So to look at this I'm just asking you not to just shut this down, not to look at it in a vacuum. Let's look at, as each effort or presentation comes up, it may extend things for a little bit, but then isn't that what you're supposed to be doing, is deciding what's relevant in the very, very broad terms of how our state law defines what that means? Any relevance at all, any arguable relevance. So that's my proposal, is that you overrule the hearing chair's decision, and that you make a determination that you're going to decide on a case-by-case basis as to whether offered evidence is relevant to your consideration. Thank you.
Thank you.
Elizabeth Lone Eagle, pro se intervener. Pursuant to ARSD 74090108, I'm requesting reconsideration of the hearing chair's January 20th, 26 order granting Clean Nuclear Energy Corps' motion in limine and requesting a full, sorry, I'm referring to notes from before. My request is not to expand the scope of the case. It is a request to ensure the scope is not improperly narrowed in a way that deprives interveners of due process and the board of a complete factual record. The motion in limine is imprecise and overboard. CNEC's motion in limine is not precise. At different points, it asks to exclude evidence related to impacts of future mining and impacts of mining generally without distinction. Those are not the same thing. Yet the order granted by the hearing chair precludes, quote, evidence regarding mining, unquote, full stop, without clarifying what evidence is actually excluded and on what basis. The lack of precision matters because it sweeps in or sweeps out evidence that is directly relevant to the exploration permit under review. Evidence of past mining and exploration impact is directly relevant. Interveners timely submitted multiple exhibits documenting impacts from past mineral exploration and mining activities within and adjacent to the proposed project area. This includes evidence of unreclaimed drill sites, disturbed soils, altered hydrology, and cumulative environmental effects that have not been remedied. This is not speculative future harm. This is documented existing impact on the same landscape where CNEC now seeks to conduct exploration. If the land is already compromised, that fact is directly relevant to whether additional exploration activities will exacerbate existing damage. Past impacts can exacerbate proposed exploration impacts. Exploration does not occur in a vacuum. Where there are unreclaimed sites, prior disturbances, or legacy contamination, the impacts of new exploration activities can be magnified. Ignoring that history does not make it disappear. It simply removes it from the board's consideration. That is not sound environmental review, and it is not consistent with the board's obligation to evaluate impacts in context. The order fails to distinguish past mining from future mining. The January 20th order precludes evidence regarding mining, but makes no distinction between evidence of past mining activities or on or near the site and evidence of future mining activities that may or may not occur. Those categories must be treated differently. Evidence of past mining is historical and factual. Evidence of speculative future mining may raise different concerns. But by lumping them together, the order excludes relevant evidence that goes directly to site conditions and environmental risk. Exploration and mining are not cleanly separated in practice. Mine development occurs in stages: exploration, development, and mining. But the techniques used in those stages often overlap. Drilling methods, access roads, waste handling, groundwater interaction, and disturbance patterns are not neatly siloed. Drawing a hard line that says this is mining evidence and therefore irrelevant ignores how mining exploration actually works on the ground. That artificial distinction limits the board's ability to understand real-world impacts. Due process requires a full board decision. Finally, due process requires that parties be given a meaningful opportunity to be heard. This motion in limine was granted by the hearing chair without interveners having an opportunity to present argument to the full board until now on the exclusion of the evidence. Excluding entire categories of evidence is not a minor procedural ruling. It affects the fairness of the hearing and completeness of the record. For that reason, reconsideration by the full board is appropriate and necessary. I respectfully request that you reconsider the January 20th order, that you clarify that evidence of past mining and exploration impacts within the adjacent within and adjacent to the project area is admissible, and that to ensure that will ensure fairness to all parties and ensures the board decision is based on a complete and accurate record. Thank you.
Thank you. Any other interveners? Applicant.
Thank you, Mr. Chair, Commissioners. You know, it's appropriate, I think, that this specific issue be brought up on the heels of the uranium mining ordinance, because it's a very similar issue, right? Uranium exploration and uranium mining are different. They're controlled by different chapters in the South Dakota Code. 45-6D-29 will guide the relevance of this commission's receipt of evidence at the hearing on the merits here. It's an entirely different statutory process and scheme regarding for a mining permit. This motion was brought because it will be, I think, as has been evidenced here, it will be important that this commission remain focused on what is relevant before the commission when considering the merits of the application. And those are the effects and benefits of the exploration activity, not past or future mining activity. And I think a lot of conversation earlier discussed the benefits of the exploration project. The applicant will focus on the benefits of the exploration project itself rather than the benefits of any potential mining that may or may not occur in the future. There is a benefit in knowing what exists, what mineral deposits exist in this location. There are benefits from Clean Nuclear Energy's employment of local contractors, of local consultants. There was discussion regarding building of roads. Again, this is a very strictly scaled exploration project that will not include building of any roads. Now, if there is a mining application there someday, as you well know, roads will be part of what you talk about. But that's not going to be what needs to be talked about here because we aren't going to build any. I think it's important that this commission consider the legislature's understanding of the benefits of a uranium exploration project. SDCL 45-6D-2 says, the relatively unknown and as yet largely undeveloped uranium resources of this state consist in major proportion of uranium below the surface. The exploration for and discovery of uranium by means of drilling and other methods of detecting such deposits are important to the economic development of the state and the nation. This is our legislature defining what some of the benefits of exploration are, certainly as they are opposed to mining itself. There's also some conversation about hydrology, and you're going to hear a lot about that, and that's going to be one of the areas where we need to maintain our focus on the exploration activities rather than a large-scale mining or an in-situ mining program. That's not what we're asking for at this point. There won't be any water pumped down any holes here that has been utilized in an extraction process. Obviously, we're well in advance of that. There aren't any underground injection permits being sought by applicant because there isn't any mining activity being sought by applicant at this time. Should there come a time when some applicant desires to extract some mineral from this location, that application will come before this commission. And that application will include the plans and descriptions of the activity that will occur. And at that time, the statutory criteria that are relevant under 45-6B can be considered by this commission, but we're not there yet. We're at 45-6D, exploration, and mining is not relevant to this commission's consideration as it relates to the 45-6D-29 analysis. Again, in order to efficiently prosecute this hearing when we get there, it's going to be important that this commission remain focused on evidence that is relevant and not stray outside of those parameters. This motion in limine was an attempt to get out in front of that and ensure that the evidence submitted is relevant to the exploration permit and does not get into the analysis of the cost-benefit analysis, as I heard it talked about, but the analysis of mining itself. For that reason, we would ask that pre-hearing Chairman Morris, that Mr. Morris's decision be affirmed. Thank you.
I have a question. If I were to add the words preclude evidence and its impacts after the exploration stage, what are your thoughts?
I think that would be appropriate. I think that it may not go far enough. As has been discussed here, there is trying to maintain my train of thought while being distracted from the back. I apologize for that. But there has been previous activity in the area, not in this location, but in the area under previous legal standards and under previous reclamation standards, et cetera. And again, I also believe that those would not be relevant to this instant exploration application. I think that your suggested language regarding mining after the exploration project is completed, or however you had that word, pardon me for not recalling it exactly, but I think that's a large step toward where we need to get, but it may not go far enough.
Thank you.
Thank you.
Mr. Blair?
Steve Blair, General Counsel for DANR. I appreciate the suggestion, Mr. Chairman, on the language. I think there is maybe some room there to modify that language. I interpreted the applicant's motion when I reviewed it as precluding evidence of they're going to mine in the future and that's going to be detrimental to the environment, and we want to talk about that. And I think, as Mr. Nas said and as Mr. Morris recognized, that is appropriately deemed not relevant when you look at 45-6B29. I also think that while there is a lot of historical activity in the area, I think there has to be a tie between the historical, whatever it is, drill hole that wasn't properly plugged or whatever, to the actual proposed exploration activity. The mere fact that there was historical mining that occurred that, again, occurred under, you know, some of it comes before state mining laws were even in effect. Some of it, as there is one case, you know, that was not appropriately carried out. But to just say that because of that, this project should be denied, in my perspective, is not relevant evidence. If there was a tie made between a particular borehole, historical borehole, that was arguably, if evidence could be shown, improperly plugged, and that impacted a proposed drill site location or drill pad location of the operation or the proposed operation, perhaps then you have a situation where that's relevant. But I think the concern was, and the way I interpreted the applicant's motion was, the sort of general, well, there was prior activity here that was detrimental to the environment, so you should deny this. I think that's not relevant evidence. And future mining activity, again, the argument that, well, they're gonna, once they determine the ore body, they're gonna mine, and mining is gonna lead to contamination of the water resources, and so you should deny. I also think that is not relevant at this time. Those arguments would come if a mining application was submitted. And so on those sort of grounds arguments, I would say maybe there is room there to modify the order. I agree with Mr. Nas that I think Mr. Greenfield's proposed language gets part of the way, but maybe not all the way. And I apologize, I don't have alternate language that's jumping into my mind that could resolve that. But I think that's where the order needs to be in order to maintain that, or ensure that relevant evidence comes before the board as it makes its decision on this application, and irrelevant evidence is excluded. Thank you.
Any response?
Well, I think this Bruce Ellison, individual intervener, the suggestion that you again make a blanket negation of what, or blanket determination of what is relevant evidence without looking at the specific situations, I don't understand how that gets to be done. I mean, and if what the state is proposing is that if there was an improperly plugged borehole 1,000 feet away, but still within the same aquifer and same in direction, flow directions, whatever. I mean, obviously we've got to show a nexus, but how do you specifically show a nexus from one borehole to one particular borehole to be drilled? It makes it ridiculous. I understand the idea of, and that's why I propose, let's look at it as as an intervener tries to bring up any piece of evidence or challenges any of CNAC's evidence or the state's evidence, that you make an individual decision about whether or not, under the context you then understand it to be, as to whether or not you'll even receive further evidence, which is ridiculous. You should certainly hear it. I mean, the state was essentially trying to argue what the hydrogeology is in the area without being specific to anything. And that's why you need hearing, so we can really get down into the nitty-gritty. Don't do a blanket, you know, try and do a definition. Other than, you know, we're not talking about, in order to look at the potential impact of a CNAC borehole on the potential aquifer, should there be a spill or a leak, or a drill bit that gets caught halfway between aquifers and unable to set up any kind of control system like we had recently in Wasta. Let the evidence comes in. How can you look at what the impact will be at a CNAC borehole by their operation if you don't understand the current conditions of that location and its immediate impacting surrounding area. We're talking about an aquifer. We're talking about one of the 4 major aquifers in the Black Hills. And again, we're not trying to decide if there's uranium there. Everybody knows that there is, except maybe CNAC is trying to tell you. But then why would they be seeking 6,000 more acres and seeking money for their whole operation? You can't make a decision in a vacuum, and that's what CNEC has asked you to do, and that's what the state suggests. So I renew my proposal that you overrule the hearing chairman and that you go on a case-by-case basis of the admissibility when you really have before you not a 5-minute presentation by a lawyer, but you really have everything that's been going on in the hearing to really understand the potential impacts. It's a much fairer way to do it, and it's a much, I would submit, it's a much better way for you to be making a decision. But if you start excluding what you're going to allow to hear, that could very well have an impact, any arguable impact, because that's really what we're talking about. But we're talking about an aquifer that's in trouble. And now they want to put more boreholes into it. And the Lakota Formation is still the principal water source for the people of Fall River County. So allow the evidence in. What does it do? Spend more time? It's not a waste of time, not if we can show, sufficiently argue that it is something that you should be considering. Because it's all one aquifer, sometimes split in 2 places, sometimes split in multiple places. But they all flow. And they all flow eventually into the Cheyenne. So, please, thank you.
I've got a question.
Yes,
So
sir.
you're a relevancy guy.
Okay, maybe.
Well, you're going to say, let in what's relevant.
Yes, sir,
okay?
I will, always.
Which I understand. But is anything relevant that doesn't apply to the exploration stage? That's what I'm trying to get at.
If there has been contamination that has already been loosened, we're talking about ore rock that then in some places has been either ground up or we're talking about has been oxidized. And, despite the representations by CNAC that, maybe there've been a couple of violations here and there or someplace, and that there are boards and everybody's in effect, I would love that to be the case. But that hasn't been the history, really. It hasn't been the history. So what I'm saying, sir, is, okay, borehole A. Let's talk really about the ups and downs of that geohydrology. And what connects to it? What flows into it? What flows from it? Because if that's contaminated, that's coming from a contaminated source, you have to consider that as to what the impact of this would be if you end up having a rupture, a stuck drill bit, or any other form of contamination.
During the exploration
During the
process.
exploration,
So you
yes,
and
sir.
Dr. Sharp don't necessarily agree.
Well, no,
you
I-
say relevance, and he says, no, I'm willing to live with a definition similar to the one that I proposed.
Well, but he's also talking about
You'll get to come up.
Yeah.
You'll get to come up.
I think he'll clarify what he means. And I don't think we're in any disagreement at all. But how can you assess of a damage, an improperly drilled drill hole, for whatever reason it's improper, that causes causes contamination of the water, that puts drill bit stuff. I mean, what are they going to do with this stuff, with the stuff that comes up? These are all things to be considered, and you have to look at how everything relates to each other. You can't say, well, I'm only going to concern myself with this mic, but I'm not going to worry about this one, even though I could press a button and they're interconnected, because it's over there, it's not here. Well, if I turn this button on and that turns this button on, that's something for you to consider. And you don't know that. They don't know that. They just want you to ignore it. And we're saying, please don't. Please let us try and show to you that there may be a problem. I mean, we're dealing to some extent in maybes, right? But your job, as I understand it, is to try and limit the risk to our water, amongst other things. That would be site-specific, but it's not sitting in a void. It's sitting in a heavily holed area that has been contaminated. So what is it going to do further? Or what can it do further? Because you have to decide how to make sure it doesn't happen. And not just say, well, tell us a year from now whether there was any problem. Because that's what has been happening. And so I'm, as an intervener, I'm trying to say, no, let's look at the problem and try and prevent it from the beginning. And not have a company reported kind of thing. You know, I would hope that if a permit was issued in this thing, you have an inspector out there who isn't in bed with the company, as they sometimes do, and they just stay out there. But you actually have oversight. But how do you know what to oversight if you don't know what the problems could be to look for?
All right,
Thank you.
I'm really ready to hear from Dr. Sharp. You're going to need. Yeah, we'll do this and then we'll take a break.
Okay. Thank you. Look, it's frustrating, I think, but I'll be fast. I'm going to read this again. The law favors admitting relevant evidence no matter how slight its probative value. The standard quote permits evidence to be admitted even if it only slightly affects the trier's assessment of the probability of the matter to be proved. So that's a pretty low bar, and the Supreme Court has been very explicit about that. The idea, I mean, and I hate it when scientists stand up and bang the table and say, I'm the expert, you have to listen to me. It's not about expertise, it's about transparency and evidence and process. But, sorry. So I'm not going to try to say, oh, I'm a scientist, you have to listen to me. But the way that science works is you integrate evidence from wherever it comes from. And to think that you can preemptively define where relevant evidence is before you know what the evidence is, it's just not the case. So you could, in very good faith, trying to keep us focused on the relevant question in your mind, say, well, we're only talking about relevant impacts at the location that we're talking about. But evidence might derive from a similar process that happened in Mexico in similar geology, and the evidence is there, and it would allow you to understand what's likely to happen in this location because somebody tried something similar in similar geology. So you would inadvertently, just by saying we're only talking about South Dakota here, you would leave out relevant evidence. Saying we're only talking about future impacts, not past impacts, well, no, the way that you understand what's going to happen in the future is by looking at evidence from the past. There is no way that you can preemptively understand what evidence is relevant. What we're actually talking about is that the hearing chair, when the actual hearing happens, should define and understand and very consistently and fairly, I would hope, apply a standard to say, this is the question we are trying to answer right now. Can you please explain how your evidence is relevant to that question? But you're going to have to assess that on a case-by-case basis. I mean, murder mysteries get solved based on, like physiology or looking at pollen spores. Like, you wouldn't expect that until you actually saw the dead body, but you can actually determine how long a body's been there by fungal growth. So if you said, we're not going to be talking about biology today, by God, this is a murder mystery, you just left out the evidence that solves that gives you the answer. That's just how science works. So what you're really talking about is your chair on the day needs to remind the witnesses, remind the cross-examiners, this is the question we're addressing. This is the scope of the question we're addressing. But you cannot preemptively guess what and then draw lines around what evidence will be relevant. It's just not possible. It's not how science works. And even if I trusted that everybody was trying in very good faith to do that, you've seen my skepticism about the functions of government, but we'll put that aside. Even if I trusted that, it still wouldn't be possible. We could all get together and in very good faith try to draw lines around what's relevant evidence and what's not. We'd still get it wrong. It's not how evidence works. I think it's antithetical to ever say in an evidentiary process you are precluding evidence. What you should be saying is we will be judging the relevance of evidence based upon its applicability to the question at hand. And that's the job of the chair on the day. Can't be done any other way.
Thank you. We're going to take a break until 2 by that clock. Thank you.
25 is 30 minutes.
If everybody could have a seat, we're going to go ahead and get started. We might wind up taking I told you I would stick to my numbering system. However, we might have to make a modification in my numbering system. But we are on item number 3. The interveners presented, applicant now has an opportunity to respond, and then Mr. Blair an opportunity to respond.
Thank you, Mr. Chairman. I believe I've already commented on this motion, and so I would echo what I said previously. And I guess in response to the most recent comments, I don't think the issues regarding the drilling is germane to the motion in limine regarding mining. If there are issues that are relevant to the drill holes and the safety of the drill holes that will be conducted by CNEC in regard to this exploration project, well, then that is relevant to the issues before this board, this commission, pardon me. But as it relates to mining itself, that's not the same thing. I mean, the reality is there are tens of thousands of water wells in South Dakota all over the place, and that is and they are safely operated for the most part, and that is precisely what CNEC is going to do here, is drill exploration holes that are, in all practical purposes, the same thing as drilling water wells. And it is that process and the benefits and effects of that process that is relevant to this commission's decision. There was conversation regarding the scope of the question, and that's exactly right. The scope of the question is whether or not the exploration project to be conducted by CNEC that has applied for a permit meets the statutory criteria and should be approved. That's what's relevant before this commission, not evidence of future mining, previous mining. If there are issues where the condition of the land surface suggests that previous activity is relevant to the scope of the project, then maybe that is relevant. But that's not what the motion in limine seeks to preclude. Motions in limine are filed in courts all the time. The idea is to help streamline the process and help the decision maker stay focused on the decision at hand. And that's why this motion was filed, and that's why we ask you to affirm the decision of Mr. Morris. Unless there are any questions.
Questions? Thank you.
Thank you.
Mr. Blair?
Mr. Chair, I don't have extensive comments. I stand by my earlier comments. I agree that the scope of the question is the impacts of the exploration operation. Motions in limine, as Mr. Nas said, are filed and granted all the time in the circuit courts of the state. The bar for relevancy is a low bar, but it's still a bar. You still have to get over it. And I think there are categories of proposed or potential evidence or testimony that would fall within the applicant's motion in limine. Could the language be adjusted to recognize that there is a very, in my opinion, a very narrow category potentially, again, depending on how the evidence comes in before the hearing, is there a very narrow category of relevant testimony or evidence related to historical drilling or mining or exploration activities within the permit, proposed permit boundary? Potentially, but there are large categories of evidence that are outside of that. And so with that, I would, I guess, join in what has become sort of a unanimous request or thought maybe that the language could be adjusted, but recognizing that there are categories, wholesale evidence, testimony or information about, well, mining is inherently bad in and of itself, and so therefore you should not grant this EX&I. That type of information, I would say, should be excluded. Thank you.
Thank you. Any responses? Yes, sir.
Bruce Ellis, an individual intervener. I kind of feel like we're just going around in circles, but And as the state pointed out, depends on how the evidence comes in, exactly. That's all we're asking for. Let's see how the evidence comes in. Don't affirm the decision. That just says you can't do anything about mining. What does that mean? And so I'm not going to repeat my arguments already. They've been made. Motions in limine do get granted all the time. They also get held in abeyance all the time. And that's all I'm asking you to do.
Thank you. Anything further? Yes, sir.
Chair,
Yes.
point of question.
Yeah.
I'd just like to make a motion to overrule Bob Morris's motion of lemony. I think we've heard plenty of arguments on this, and I think this is something that should be addressed by the board at the time.
There's a motion to overrule the motion in limine. Is there a second?
Grunwald seconds.
Further discussion or discussion amongst the board?
What would it say in Carpin? What would it say instead?
In my mind, it wouldn't say anything. I actually fall in the relevancy camp. We have federal rules of evidence, we have state rules of evidence, and I do not like going ahead of. Now, there are clear things that should never come in a trial. Federal rules of evidence say what those things are that don't come into evidence. But for us to say ahead of time, this is relevant and this isn't relevant, I think that Mr. Morris will do an excellent job making that decision.
Thank you.
That's me. Any further discussion? Yes, ma'am. If you could come forward. Oh, yeah, I'm sorry, we're done. No more. Yeah, well, the board has a motion before it, so that's where we need.
We're not going to talk about the previous motion?
No, we're going to talk.
We'll have the opportunity to talk, is what I'm saying.
No, now it's just amongst the board. You're right. Pardon me?
Why was I ignored?
I did not see you. I did not see you.
Name, Jean Roach.
Come on forward. Yeah.
Jean Roach, Cheyenne River Sioux Tribe, I'm my intervener. But I don't really quite understand what you're saying, that you don't want evidence of previous atrocities entered into this court.
I did not.
Or whatever it's called.
I did not say that.
Okay, what are you saying?
What
Can you
I'm saying
explain
is
it to
the
me?
standard for determining whether evidence should come in at the hearing is the standard of relevancy. And whether it's relevant or not is going to be determined by the hearing chair. So you're digging yourself a hole right now.
No, what I'm trying to understand is what is going on. Do I need an interpreter to interpret your word?
No, you don't.
Well, what I'm saying is that I feel that evidence of birth defects or water contamination are part of it. Are you saying that you're going to determine by each hole or just a blanket thing like they talked about, that is not going to be considered?
The answer to that is no. We have a motion before the board to overrule the motion in limine. I'm sorry, now we're at the point. What you need to understand is we're saying that the motion in limine is overruled, okay?
You had a vote on that just
No, we have not had a vote on that. That's what we're trying to do.
Okay, well, I don't understand what the hell's going on here.
And that's okay. That's what we're trying to do right now.
And the
We're not trying
official
to ignore
motion,
you.
what does official motion mean?
It means that there is no motion in limine, and that when evidence is presented at the hearing next month, when that evidence comes up and there's testimony, there's a party that can object to the testimony or say nothing, object on the basis of relevancy, hearsay, whatever, and Mr. Morris will rule on whether or not that evidence can come in.
Can we really objectively make a ruling with the previous stuff that he said here? I don't really feel like we're being treated fairly with racist,
Yeah.
I mean, Really?
No, you're being treated fairly, and now I'm gonna.
No, I don't feel like I'm being treated fairly is what I'm saying. And how can we expect him to be fair with his record already? For one person to make that decision? That's not fair.
You have the ability to appeal. his
Mr. Chair,
decisions.
I'm calling
Yes.
the question. I'll answer one question. You notice you haven't seen a unanimous vote here yet. There's been a divided vote
That
on every
wasn't the
motion.
question that I
Excuse me, I
said.
am speaking, if you don't mind.
Well, I was speaking
I am
if you don't
speaking
mind.
first, ma'am.
Why do you get to go first?
Yeah, let's go with the, thank you for your testimony. And now we're going to work on the question. We have a motion to overrule the motion in limine, which has been seconded. There has been brief discussion. Is there any more discussion amongst the board? Any further discussion amongst the board? None? Call the question, Brenda.
Ewing? No. Grunwald? Jessica?
I'm sorry, I just can't remember what it is, yes or no?
You second the motion, so you.
No, can you say the question to me again?
The motion was to overrule.
Yes.
Haig?
Yes.
Carpin?
Yes.
Miller?
Yes.
Morris?
Abstain.
Schultz?
Yes.
Blumhart?
Yes.
And Greenfield?
Yes. Motion carries. Relevancy will be the standard at the hearing. What was the total, Brenda?
7 yes, 1 no, 1 abstain.
Thank you. Next item on the agenda is translation services. And I don't know if we have our person here to present. However, I'm going to present something. Can I have your phone? House Bill 1219 passed. It does not become effective until July 1st. When a bill gets passed, unless it has an emergency measure, it does not come into effect until July 1st of the year in which it was passed, okay? So is this bill currently in effect? The answer is no, this bill is not currently in effect. However, this is what the bill says. Well,
You're going to want to skip down to right there with that paragraph.
a party in a contested case proceeding may appear in person or by counsel or both. Hang on, I'm trying to find. May obtain the services of a translator or interpreter as provided in Chapter 19.3 with the translator or interpreter's compensation fixed, paid, and collected as provided in Sections 2 and 3 of this Act, may have reasonable opportunity to inspect all documentary evidence, may examine and cross-examine witnesses, and so on and so forth. That is not currently the law. The ruling by the chairman was not to allow translation.
I would also make reference to Section 2.
There's a new Section 2, when a witness or party needs a language interpreter or translator in a contested case proceeding, the agency required by law to determine the matter as referenced in a certain subdivision shall procure and appoint a disinterested interpreter or translator. So the procedures are set forth in new House Bill 1219. Now, the point is whether or not this is applicable at this time. And that's what I would like to hear people's testimony on. Interveners.
We've been able to contact Ms. Lone Eagle, and she is on her way, and I certainly don't want to cover her testimony. And I understand what you've just explained, Chairman Greenfield. I would just like to if it does not, it seems to recognize that a person who does not fully understand English may have the right to an interpreter paid for by the state, is what the law to go in effect in July says. I would ask the board to, if it doesn't decide to implement that early, that it would allow a party who feels they need an interpreter to bring an interpreter. And for, during the course of proceedings, I mean, I've been at hearings where there's been interpretation before, and it does seem to lengthen it a little bit. If the interpreter for the individual or individuals, because like any language, it's somewhat subject to interpretation. But in other words, to allow for the benefit of an interpreter to be present with non-English speaking or non-sufficiently English speaking persons to understand, and for the hearing examiner to give some leeway to allow for that translation to take place, so that the benefits to the person who wants to understand and participate still gets that benefit, without it being a general public statement, which it usually is, where the interpreter comes up, as I'm sure you're aware, and then interprets for the record, which would be a nightmare for the court reporter. I mean, I'm not a Lakota speaking person, so I can't, other than a few words. But this would allow then for it to happen. And I'm just asking for some leeway to allow it to happen, even if the board doesn't authorize funding of any individual. Thank you.
Thank you. Anyone else on behalf of the interveners? Yes, sir.
Hello, Taylor Gunhammer. I would just like to sort of echo Mr. Ellison's statement. I have also been to hearings where there was translation present and it was fine. Today I've been to one. We saw it earlier that obviously we in our community care enough about the non-English speaking members of our community to get them here. And so really what we're asking is for our language to be allowed in a judicial proceeding. You know, I know I'm the one to come up here and give you a hard time, but this one, seriously, about translation being allowed, is a no-brainer. Thank you.
Thank you. Dr. Sharp.
Yeah, thanks. I also am not here to give you a hard time on this particular occasion. This is an easy one. I mean, the will of the citizens of South Dakota has already been reflected in the fact that their elected representatives passed a law. And this motion was already before you. It's an easy thing to say the will of the people is clear. This motion was already before us. It should be granted, and you could implement it either by just implementing the wording of Ms. Lowenigle's proposition, or you could implement it by saying we are going to implement House Bill 1219, even though it doesn't actually take effect elsewhere until July 1st. It's an easy one. We're here to reflect the will of the people. It's now South Dakota state law. I mean, it would look really bad to be like, well, these guys weaseled in just before the deadline, so I guess they're off the hook. It's not the will of the people, and I think that's an easy thing to implement.
Thank you. Applicant, or are there any, I'm sorry, are there any other interveners that wish to speak?
Mr.
We
Chair.
have one more person, sorry. Please come forward.
Just while she's on her way forward, Tanya Stans has raised her hand to request to speak online as well.
Okay, we'll do this first and then we'll do that one.
Yes, Jean Roach again. By denying this, it just really has some racial undertones. I don't know if you guys speak second languages, but we have a lot of people that they might speak some English, but they don't understand. I mean, I speak English, but I don't understand half the words you guys are saying. So helping them understand how important, I mean, you understand how important this is to the people that come here and testify. You know, you're gonna go home, but you don't go home to Fall River County or wherever you're from. You go somewhere else. I feel that letting them know that's important to understand what's going on is part of your job of listening to the people? Or do you, are you, I don't know, that's part of your job, I thought it was. And also, there's another issue that one of my friends brought up earlier, is that they need help with the hearing what's going on up here. They haven't heard very many words, so maybe adding that as an option of, like, a lot of older people don't they can't hear real good. So maybe I'd like to just add that as another requirement so that people can get the full story. Because we don't want to have everybody making decisions without having all the facts. So part of the translation and the interpretation is important for us to basically have human rights to be able to understand what's going on with, to understand how this mining will affect our future. And we're talking about our future. Maybe I feel like you guys don't really understand where we're coming from. Maybe you need an interpreter, because we feel that this is our land, this is sacred. And being able to tell you guys from a person's perspective that can't put in English words is important for you to hear to make a great or better decision. So that's all I have to say. Thank you.
Thank you. One more. Hello.
Hello, Denise Gallego, intervener. I'm also an enrolled member of the Oglala Lakota Nation. I believe we're waiting for Elizabeth to come back because she worked very hard on that bill. Is she here now?
She's here in the back.
Okay, great.
Yeah, and before you come forward, I've got somebody online. Yes.
Tanya, I believe you're up.
Hello?
Tanya, you may have to call in again. It seems like your microphone is just broken. It's just not coming through.
Come on up. We'll try to make it work. What we've already discussed is that South Dakota passed House Bill 1219.
You lied to me. It's all right. Elizabeth Lone Eagle, intervener. At the pre-hearing conference in August of 2025, the hearing officer told the pro se interveners, "The law is the law. If you don't like the law, you are welcome to try and change it." Well, Mr. Morris, you shouldn't have threatened us Oglala with a good time, because that is exactly what has happened. I'm here today not asking you to change the law, but to follow it. Before I go further, I want something clearly on the record. 4 of the 5 Lakota-speaking interveners were present here today. Some of them had to leave due to a family emergency. Among those present, is at least 1 and possibly 2 individuals qualified to provide in-person interpretation, which you saw earlier today. In addition, another qualified interpreter may be available remotely. Helen Redfeather, is she still here? Still here somewhere. Helen Redfeather, the pro se intervener whose experience gave rise to what is now known as Helen's Law, is one of the 4 Lakota-speaking interveners present. So this is not a question of feasibility. It is not a question of availability. The people are here, the need is clear. What is missing is authorization. And that is the issue before you. This is not complicated, it is not novel. and it is not discretionary. It is about whether this proceeding will comply with the basic requirements of due process or continue in a way that excludes an entire class of participants from meaningful participation. Lakota-speaking interveners in this case cannot fully understand these proceedings without interpretation. They cannot meaningfully respond to evidence. They cannot fully present their own testimony. Without interpreter services, they are not participants. They are spectators in a proceeding that directly affects their land, their history, and their rights. That is not due process. Due process under the 14th Amendment requires a meaningful opportunity to be heard at a meaningful time and in a meaningful manner. A hearing conducted in a language a party cannot understand is not meaningful. It is a closed process in plain sight. And this board does not have the authority to conduct a closed process. Under the Supremacy Clause of the United States Constitution, federal constitutional protections govern here. South Dakota's own constitution affirms that, and South Dakota law makes it explicit. State actions that conflict with the United States Constitution are void and may not be enforced. So this is not about preference. It is not about convenience. It is about whether continuing this proceeding without interpreter services violates due process. And it does. The harm is not theoretical, it is ongoing. Deadlines have moved forward. Filings have been made. The case has progressed, while Lakota-speaking interveners remain unable to fully understand or participate. That's not neutrality. It is structural exclusion. This lack of access is not difficult to correct. The board can ensure that all 5 Lakota-speaking interveners are provided the same allotment of time with qualified interpretation services and allowed to participate fully in accordance with the existing pre-hearing schedule already set by the hearing officer. That is a manageable adjustment. What is not manageable is allowing this process to continue in a way that denies meaningful participation and then attempting to defend the outcome later. The board is faced with a choice. Take a small amount of time now to correct this error and proceed on a fair and constitutionally sound record, or move forward as is and risk a much longer legal process that will scrutinize this record, challenge the validity of these proceedings, and very likely overturn any decision that is reached in favor of the applicant. This board has both the authority and the obligation to correct that. Your own rules allow you to modify procedures, adjust schedules, and ensure fairness. Fairness in this context requires language access. Now, the state of South Dakota itself has spoken clearly on this issue. House Bill 1219, as you referred to earlier, signed into law by Governor Roden on March 9th, also known as Helen's Law, requires that interpreter services be provided in contested cases and that the agency procure and pay for those services. It passed overwhelmingly in both chambers. It carries a fiscal allocation, and it exists because of exactly the kind of exclusion I'm addressing here today. While its effective date is July 1st, 2026, the principle it codifies is not new. It is a recognition of what due process has already required all along. The state has already acknowledged through both its legislature and its governor that interpreter services are necessary to ensure fairness in proceedings like this one. And I will say this for the record. I think it's a shame that there are people serving on boards such as this one who make such crucial decisions, yet need a specific law written explaining civil rights, such as due process of law, to them, including attorneys working for the South Dakota Attorney General's office. So the law has, in fact, been changed. The question now is whether this board will continue to operate as if it has not. To continue denying interpreter services after the constitutional issues have been raised, after the record has been developed, and after the state itself has enacted a law requiring those services, places this proceeding on unstable legal ground. And I want to be very clear about what that means. If this board allows this case to proceed without providing interpreter services, it is not simply a procedural decision. It is a constitutional violation. And constitutional violations do not stay contained. They invite challenge, they invite review, they invite federal jurisdiction. That is not a road this board needs to take. The remedy is simple. Authorized, qualified Lakota interpreters for all phases of this proceeding. Adjust the schedule as necessary to ensure meaningful participation and allow this matter to proceed on a record that is fair, complete, and constitutionally sound. This is about whether this process has legitimacy. A decision reached while excluding the very people most affected by it will not stand, legally or morally. However, process that ensures full participation, respects language access, and complies with due process, that is a process this board will be able to stand behind. And today, that choice is yours. Pila Maea.
Thank you. Anything further? Applicant.
Mr. Chair, we didn't file anything in response to the appeal. I have no objection to the translator. I'm available for any questions, but we don't have to give a position on the appeal.
Thank you. Mr. Blair.
Mr. Chairman, Steve Blair, General Counsel for the Department. The question you posed at the beginning was whether the law is applicable now. The law is not applicable now. Having said that, it's always, in my opinion, within the board's discretion whether to grant in translator services or not. And as you've heard from several of the parties that have testified, the law bill, soon to become a law, is definitely a exhibit or loud statement of public policy in this state as passed by the legislature. The department does not object to providing translator services. However, the questions that come to my mind when we talk about translator services are procedural questions. How do we ensure that the people who need them receive them? Is there going to be some sort of request process, application process? Does it need to be in writing? Can it be by an email? Certainly, we would have no objections to parties providing their own translator services. But those that don't want to do that and want to avail them of the soon-to-be law, how does that happen? And how much time does that take? How does that affect the schedule that's been established? When we get to the hearing, what the bill doesn't answer is, how are translator services provided? Are they simultaneous with testimony that's occurring, or is it alternative? I've been in court and seen it both ways. Both ways have their pros and cons, but that's not established in the bill. Something I think the board would need to consider, or the hearing chair would need to consider, how that's going to proceed forward. And the other open question to me is there some sort of certification? Is it within the board's implied authority to require some certification of those who do provide translator services, or oath or something, if you will, acknowledgement that, yes, they're here as a translator, they're trained, or just by their upbringing or whatever, they have the ability to provide these services, and they translated true and accurately. Those are the types of questions that I think are outstanding. The bill is not in effect. It is a valid statement of public policy. It's within the board's discretion to provide translator services, but some of those other questions should also be answered in providing those services. Thank you.
Mr. Chair, I believe Ms. Stans is now available to comment. Ms. Stans, are you available right now? Can you hear me and speak?
I'm ready. Thank you for coming back to me.
Ms. Ellen Red Feather would like to speak again.
Yeah, let's take the one on the internet. If you could please have a seat, then we'll take that one, and then we'll come to you. Is that acceptable?
Yes.
Ms. Stans, you're good to go.
Okay. I just wanted to bring up SDCL 1-27-20. And so it passed in the legislation, and it's where they made the official language of South Dakota, Oceti Sakowin. Oceti Sakowin is 3 different language dialects. So, just thinking about government, how even this state of South Dakota's government got established, based on the treaties. The only reason the treaties are even upheld or even able to, talk to anybody is because they had interpreters, So today, and you think it's not a racist situation, or you don't want to see your racism, but you're literally just designed this so somebody can't have our relatives don't have their right to speak or talk. And that is a human right violation. So you should think about that. And seriously, this should never be an issue. And this issue of going to July, you want to push this to July and have more, more on you? I mean, this looks bad from South Dakota. We live with this in South Dakota, this type of racism. But to ignore us like this, to ignore our languages, and then, maybe y'all should go over to the South Dakota Department of Education and look at our Oceti Sakowin, all the work they put in there. That's a disrespect to yourself and your own government. Thank you.
Thank you. You may proceed.
Reservation Elwati. Na lea petu ke misnala malakota wasni maya tiata lila ota lakoti api. Na mizo yaka khmigapsni le ehani ne 17 ton na haya hin na cheche. Wasituki. Ya hipsna nyonke lakotu nyapi. We had our language api. So he unguru hapi hetsina lea petuki. Leta kweli ni watu tupi. Heni ni kawapi. Maya he treaty ma he aikaka yanke. Na unke la khoti yanki la kholia unkuna unki chagapi. Na leta kula ya kawa na lete sevitasha yankona. Alta taku kalu sitapi. Mini he witoni yapi. Unki I don't know about you yapi. But you so yapi. Pipeline in the egg na kapi wasituki. Hena kak station ke happy. As hetu na hetu. Na many onki hockey wana sija. Theater. Lena hips nani. Ihani. Ihani we toy chaje. Heha hetu pi he. Le ha honki le. Mine ki le. Na heta mini ki he yu sita na leang petuki. Un tibek ta heta. Sita ki le na hina mana. Witokuza. Witokuza. Sickness. Cancer. Hena unha na umut api. Na akele le na timahi upeti. Hena ake hetun tata. He hani beginning of time yapi. He hani yahiu na taku ka lusi tapi. Taku ka. Mini ato unchi makati fia yakuapi. Taku one rate at the hetani pi. Unchi makahetum sa yakuapi. Mana we lena. We okana kiki lena. Mini shita. Owa ile. Unchi makata banks wana ato bule hit. Lushita pi. Na ake hetani pi. Maya hakoza luchabuha. Hena mini at kampi. Hena mana koshite. Umi chate. Sahechu ukija ichona laksi. I hechu na ato na no ponya chinsin.
Point of order,
Hena
Chairman.
na hina jina. These
I think she needs to be addressing us,
other no
going around the audience.
I can go keep some. That one was she to have after.
If I may interrupt for one moment, I mean, this is somewhat illustrative of the problem. We need to, at some point, you know, when you're translating, we need to hear what you have to say, because, do you understand, like?
Out of respect, can I say something? I can't speak.
Go ahead.
I don't mean to cut you off, I just, we don't know.
Okay, because of respect, I can't speak over her.
Okay, I understand.
Yes.
Could
Her name is Helen Red-Feather. She resides in Wounded Knee area. And what she's stressing is that we go to the Black Hills to pray, and we don't go to your church, and we don't come to bring dirty things or bad things to your church when you pray. But these people are coming to contaminate our water, everything. We're already getting sick from what is already going on with the pipelines that come through. Lakota is our first language, was my first language too. And oh, by the way, my name is Bud Lonigo Sr., and I'm from member of the Cheyenne River Sioux Tribe.
Thank you.
Yes. I'm the translator. I'm also Lakota. I speak Lakota and Dakota, so two of our dialects is what I speak. A lot of things that she stressed is that they've already contaminated the Mother Earth's veins of fresh water, and that's what's killing us. That needs to stop. You know, our people been here. We've originated here. We've originated from this continent. We're not born like everyone else is. We don't want these. We don't want this poison coming through our water that we drink. And we're going to continue to live regardless. But this has got to stop.
I guess I call it question, Chairman. We're talking strictly
Thank you.
about translation services.
Translation services? Yeah. Well, that's what I'm doing.
Yeah.
I'm expressing what she said. So that's what I'm doing. I think the courts also need to get their own translator too. And they need to get their own translator. You know, there are more people back home, we call it home because you put us on this. They need a translator because there's more of us that only speak Lakota or Dakota or Nakota. There's many of us that still speak that. Hardly some of us can speak English. You know, our people are here, and our people need to be heard, and we need to be able to understand the English language by you guys providing a translator for us. So that's what she's expressing.
Thank you. Do you have anything further to add?
Yeah, water is life.
Thank you.
Can I respond to what he brought up?
Come on up.
Elizabeth Lonigal, pro se intervener. I wanted to respond to some of the things that Mr. Blair brought up. And that was with, respect to how is this going to look? Where are we going to, what's the certification process? It's like one roadblock after another. Like was said earlier, by Mr. Gunhammer. You keep moving the goalposts. You told us to change the law. We changed the law. We did that. We went through those motions. And there were questions about some of the very same things that Mr. Blair brought up. And if he had been following that law, like I have my LRC, I looked up, I followed laws. I followed this one. I don't know what his access is. But if he would have followed it and listened to the hearings, a lot of those questions came up. So there's already answers on the record for those things. There is a network of translators. The civil courts and the criminal courts already have resources that are available for your use for this. There's already answers to those questions. It seems to me like things that should be your job now to do, that we did what you told us to do, that's in your court now. You're the one that has to get over the goalpost. Because like I said earlier, this is a civil rights issue. This is not going to end up in a state court that's just going to rubber stamp whatever you want to do for them. This is going to end up in a federal court. And have your attorneys and your legal researchers look. When tribal members go to federal court, we win.
Thank you. Bruce.
I have some suggestions. Chairman Greenfield. Bruce Ellison, intervener. I first wanted to thank CNEC for lack of opposition and Mr. Blair for, bringing up points that Ms. Loneagle pointed out may have already been answered, but part that I think has not been addressed, and I think you raised the issue, Chairman Greenfield. How would this work at the hearing? And certainly using the interpreters that have already been certified by our state or our federal courts would be an excellent resource, would be certainly one way to find qualified personnel that would then that would not be the issue. Whether you would choose to have your own interpreter as opposed to the witness, or we just have one, that is up, that would be up to you, certainly. But the way I've seen it work most effectively, if a person goes on for a half an hour in English, how do you translate that into another language and keep the context and keep the rhythm and everything going? And it's hard. As someone who's done I've done cases with interpreters, it takes a little getting used to. But what I would suggest would be the interpreter serves as the function of interpreting. If any board member is speaking, that what I would ask would be that we break up what you're having to say into segments, logical segments, so that they can then be interpreted and then go on to the next segment. So it takes a little getting used to, but what this allows is contemporaneous understanding, which I think is really, really critical. So if a witness is testifying, they can do the same thing, and the witness testifies, and it may take some help from the chair. Just say, well, could you hold for a second while that gets interpreted, because it seems like a logical place to then give a 3 or 4 sentence or 1 sentence interpretation. So whether it's the testimony of a witness, whether it's a statement by any member of the board, or if a Lakota witness were to testify, that in order to make a good record of it, that we then again break it to segments, and then if it's Lakota to English, then when the English is finished, the Lakota continues, and vice versa. It's workable. It's been done before. It allows for the interveners then to really know what's going on as it's going on, and not have to remember back what happened 10 minutes ago because it was such a long statement. And again, we'll all have to be doing adjustments. It does make it a little bit longer, but it really then allows for a full input. So that's a logical way that I've seen applied in cases I've been in federal court and state court. If we have someone selected from the lists of state or federal interpreters, that we don't have a discussion really about, well, did he really use this word or that word? We get one interpretation, and to some extent, each side is going to have a little bit of, may not be happy with every word. And And I mean by side, I mean English speaking only and Lakota speaking majority or only. So this is a workable solution. Again, it does take longer, but I cannot express how meaningful it would be to the Lakota interveners and Lakota people, Lakota and Dakota as well, that to have someone actually interpreting and letting people know, even the people that might be listening on the phone. Thank you. I know you're at the point of calling the question, but I just wanted to add that procedural suggestion. Thank you.
Thank you. Okay, any further response? Mr. Blair? Yes, Doctor.
Just a very practical suggestion, and I don't know on what time frame it would be required to acquire the infrastructure to do this, or the technology. I previously represented governments in international science forums where there was 4 official languages, and we had headphones, and you select your language. Every word is translated in real time, so it meant you were not required to stop, and everything didn't take twice as long. I think that this is South Dakota state law. It would make sense to acquire the technology so that in this instance, it would seem that you would equip all of your Lakota speakers with headphones so they could hear translation to English in real time all the time. And then your English speakers, probably because you don't want to have to buy that many sets of headphones, when somebody is primarily speaking Lakota, then you would take the time to translate and actually have the pause. But with the investment in headphones and with an interpreter who's capable of listening and speaking at the same time, which is not easy, especially when it was French, Russian, and English all at once, and Spanish. But in this instance, we're talking about 2 languages, and I think it would be a useful investment and would streamline the whole process. That's all.
Thank you. All right, the question has been called. So the question is whether we uphold Hearing Chair Morris's order or we overturn Chairman Morris's order, or we overturn with modifications. Is there a motion that the board would like to make?
Mr. Chairman. Jessica Grunwald. I make a motion to overturn Mr. Morris's ruling.
And can I add something onto your motion? And that we proceed with House Bill 1219, those methods. And I am a believer in the I'm a believer in the instantaneous translation. Okay. So I guess the chair is amending your motion. Is there a second?
Miller seconds.
Further discussion of the board? Hearing none, Brenda, call the roll.
Ewing.
Aye.
Grunwald.
Aye.
Haig.
Aye.
Carpin.
Aye.
Miller.
Aye.
Morris.
Abstain.
Schultz.
Aye.
Blumhart.
Aye.
Greenfield.
Aye. Okay, next item is item number 5, which deals with the service of process. Now, I'm going to use one of Bruce's phrases. I think this is a no-brainer. I think that the state statute provides how service of process is to occur, but do any of the interveners have any comments on that issue? Please come forward.
Elizabeth Loneagle, pro se intervener. And I just want to make something short because I'm the one who kept pushing the issue. And that is that, you're right, it is a no-brainer. We have the technology. All it needs is the authorization to be able to do it to those who have requested it. And to those that don't have the technology readily available, that we allow for those accommodations. It's real simple. Thank you.
Any other interveners? Hearing none. Applicants?
Thank you, Mr. Chair. Again, we didn't respond to this appeal. Don't have an issue on electronic service. I think frankly there are some benefits to it, but statute is what statute is, so we're not taking a position on the appeal. Thank you.
Thank you. Mr. Blair?
Mr. Chairman, Steve Blair, General Counsel for the department. Yeah, the administrative rules 740901, I apologize, I don't have them in front of me. There is a rule there that defines what constitutes service, and that rule unfortunately doesn't allow for electronic service. And that, if I recall correctly, was the basis of Hearing Chair Morris's decision, and we would recommend and encourage that the board continue with that decision. Those rules are your procedural rules, and they just do not allow for electronic service. And so with that, we would ask you to uphold the decision of the hearing chair. Thank you.
Bruce?
Bruce Ellison, individual intervener. I appreciate that most of the filings are done. This would make it so much easier. I would suggest that perhaps the board consider, what is allowed is it could be done by fax machine. Well, we don't have, that's in a form of electronic service. It just prints out a page at the end. So really, if the board were to allow for electronic service under the idea, well, it's an updated version of a fax because it's really just transmitted electronically to a place that happens to print it out, which we can do with our printers attached to our computers, and the board can too, that the board consider allowing for electronic service for evidence or anything else that the board might request, because some stuff is voluminous. And I know that you may require a whole bunch of copies, and it would just make it so much easier for everybody and bring us up to the current age, and that hopefully our legislature would listen and say, gosh, we got to change this, because nobody uses fax machines anymore. But it's kind of the same thing. Thank you.
Anyone else? Applicant? You're okay? No response? No response from the state? Is there a motion from the board?
What do you want? Whatever everybody wants, fax, text, I mean, let's.
How do we document or receive it?
Well, it's got to be, the statute's the statute.
Yeah.
Do you want it by mail? I mean, there's.
Well, there's a statute that says how we do it.
Well, I know, but.
And that's what, and Chairman Morris ruled that we're going to proceed with service by what the statute requires.
What's the administrative rate required?
Mr. Chair,
Yes.
Ewing, I'll make a motion that we support Chairman Morris's decision.
That we approve. All right, that's the motion. Is there discussion amongst the board? Oh,
Miller.
sorry. Is there a second?
Miller seconds.
Miller seconds. Further discussion amongst the board. Hearing none, the motion that was seconded was to approve of Chair Morris's decision. Brenda, call the roll, please.
Ewing.
Aye.
Grunwald. Haig.
Aye.
Carpin.
Aye.
Miller.
Aye.
Morse.
Abstain.
Schultz.
Aye.
Blumhart.
Aye.
Greenfield.
Aye. Last but not least, number 6, the catch-all. Which states other orders issued by the hearing chair at the request of the parties or the interveners? Number 6 states that the last item is other orders issued by the hearing chair at the request of the parties or interveners. At the request of would mean, do any of you have objections to any of the other orders that were issued? Please come forward.
Elizabeth Lone Eagle, pro se intervener, and this is regarding scheduling, which you would not let me talk about earlier, even though it was a part of the venue change appeal. So, to repeat, the record before you is undisputed. This contested case involves 36 parties, including individual interveners, organizations, tribal governments, state agencies, and the applicant. The parties have identified at least 21 expert witnesses and more than 20 non-expert witnesses. Despite that record, a 3-day hearing has been set with the express expectation that the matter would be conducted within that window. That decision conflicts directly with SDCL 12618. The statute does not promise efficiency, it promises participation. It guarantees that parties may be present during the giving of all evidence, may examine and cross-examine witnesses, and may present evidence in support of their interests. At the January 6, 2026 pre-hearing, interveners raised 2 distinct concerns regarding scheduling. First, they raised concrete scheduling conflicts, including religious and cultural conflicts, as well as personal accommodation issues. Those concerns were denied outright. No findings were made. No balancing analysis was offered. No alternative dates were explored. Second, interveners raised the obvious mathematical problems of fitting this many parties and witnesses into 3 days while preserving meaningful cross-examination. The response was that the attorneys should be efficient, with little to no regard for the participation of pro se interveners, most of whom are not, nor do we have, attorneys. During the same January 6, 2026 pre-hearing conference, the hearing officer further complained on the record about the inconvenience the hearing schedule posed to his own personal calendar and attempted to pressure and intimidate parties into reducing the number of witnesses and exhibits they intended to present. This conduct constitutes a violation of due process and a glaring effort to chill participation by interveners in direct violation of South Dakota law. Efficiency is not a statutory substitute for due process, particularly where unrepresented parties must navigate expert testimony, evidentiary rules, and cross-examination without the benefit of counsel. The prejudice is not speculative. Interveners who call witnesses must arrange travel and lodging. Under the current schedule, there is no way to assure that witnesses will actually be heard, let alone fully examined. The result is a process where participation is formally allowed, but practically forbidden. That is not what SDCL 12618 permits. For these reasons, I ask the board to exercise its supervisory authority and require a schedule that reasonably accommodates the number of parties, the number of witnesses, and the statutory rights guaranteed to all participants. I'd also like to address a comment that was made by a board member earlier, that we've been here a long time today, and this is our time to be heard. And that particular board member made a comment of annoyance about, well, let's just move on because otherwise we're going to be here for 2 days. But that's what you signed on for. This is our place as citizens. This is our public participation. You didn't have to take these appointments and commit to following these laws and these processes. And in the decision you just made, you were incorrect in stating that you were following a statute. You were following an administrative rule. A rule is a rule, but a law is a law. And the law can prevail over a rule. So when we're talking about due process of law, You made an error in the decision you made just previously. I hope you're not going to make that same error now. Thank you.
Thank you. Any other interveners?
Bruce Ellison, individual intervener. I would echo the remarks of Ms. Lono. And I would also add for consideration that we remember the last time a uranium operation came up before the mining board, talking about that in terms of Dewey Burdock. If my recollection is correct, after 5 days of hearing, we were not quite done with the company's presentation, the applicant, or with the department's presentation. That was 5 days. Approximately the same number of witnesses, probably the same number of interveners. So in setting the time for this hearing, because Ms. Lonia was 100% correct, if you're not here to take whatever time it takes to do this right, please resign immediately. You owe it to all of us, the people of South Dakota, to do that. If you predetermine this issue, you need to resign. But in making your decision as to what will meaningfully allow for due process, if you set it too short, we're going to have to come back. If you set it too long, we can always stop when we're done. So I would ask that that be considered. I mean, aside from if you increase it, we've got to figure out when the center is available in Hot Springs. And so I just want reasonable, practical considerations taken in this determination, so we don't have to bifurcate this hearing because it interferes with your ability to, how can you remember something 4 months before, all the details? It just makes it really hard. So for fairness for everybody, for our presentation, you're listening, you're making a good, heartfelt decision based upon the facts and the laws. Please extend a time that would be reasonable. Let's just do this once and then we're done. Thank you.
Thank you. Any other interveners?
Mr. Chair, just so you're aware, Ms. Stans is wanting to have a word as well.
Okay, let's take the doctor and then we'll go.
Dr. Lilias Jarding, intervener. I want to second some of what Mr. Ellison said. There's at least one of you here still who is around in 2013, the last time we had the hearing that Bruce referred to. And if I remember right, there were 29 interveners. Not all of them were active. And after 5 days, the company had not come close to finishing its presentation, is my memory. But, I'd rather be in Hot Springs or going back and forth to Hot Springs for 5 days now, 3 days later or something like that, than try to cram it all into 2 days. And I also agree that it's not a matter of the convenience of the board members. It's about everybody getting their opportunity by law to be heard. Thank you.
Thank you. Anyone else? Oh, wait, I promised. I promised the online. I'm sorry, but I promised the online.
Ms. Stans, are you ready to speak?
Yes, I am.
Okay, you can go ahead.
Hello again. My name's Tanya Stans. I was just also an intervener. I concur with asking for a longer period of time. I feel like the 3 days is rushed. It feels like just with a lot of the witnesses and everything that we're looking at, my concern is ceremonial use, and our ceremonies, drill bits in our ceremonies, big drills, big leaching ponds or waste ponds, in that ceremonial area. And so this is leading up to my concern for I think it was like an archaeological walkthrough. And in that pre-hearing, they were talking about sending us out there with them as interveners for 1 day to look at the area. And coming from, I guess, the ceremonial use, the female background, like that is my primary concern out there. So I feel like when that opportunity comes for us to go out there, I wish this time to go out there would be longer than just 1 day. That's all. Thank you.
Thank you. Mr. Mayor or Tyler, whoever wants to.
We're on first name basis now. It's awesome. So I just wanted to concur basically that 3 days is not nearly enough. And I find it really telling that much of what we have discussed here today was a part of the huge, sweeping summary judgment against interveners to favor this mining company because Bob Morris had big feelings one day. And this scheduling doesn't really read any different. We are being denied the full due process guaranteed to us by the law. And considering that that is what we are asking for, I think it only makes sense for the board to extend the time of the hearing. 3 days is not enough. And we honestly, as a community, a Black Hills community, we are not terribly concerned with the fishing season of whoever. Thank you.
Thank you. Mr. Mayor?
I'm not an intervener, but I'd just like to speak to the scheduling. Because we didn't know whether you folks would approve moving the hearing to Hot Springs or not. We didn't reserve any days at our Mueller Center, which is where we would want to have the meeting. But I learned today that the meeting in Pierre was scheduled for April 14th, 15th, and 16th. So I have confirmed that the Mueller Center is available for those days. But if you choose to expand it, I don't know whether the center is going to be available for when you choose to do that. We schedule it for weddings. We schedule it for just a lot of city activities. So it may be already scheduled for days that you would choose to move it to. So I'd ask that when you settle it, if you decide you're going to expand it, and when you look at some dates that you would want to do that, if you would give us an opportunity to see if the center is available and figure out whether we need to move anything or not. And the other thing I need to add to that is council is the only one that has the authority to make those kinds of decisions. I can advocate for something, which I absolutely will. I'm hopeful, I'm confident that council recognizes the appointment of this or the importance of this, and they would want to work towards getting this hearing taken care of. But at this point, I can't tell you for sure what days it would be available until you've decided if you're going to expand it and what days that's going to be involved. So I would ask you to work with us as you work through this decision. Thank you.
Thank you. Anything else from the interveners? Hearing nothing, the applicant.
Thank you, Mr. Chair. You've heard me say this before. SDCL 45 6D 28 requires a final decision on an application be made within 90 days of the receipt of the application. We're sitting here over 2 years from receipt of the application by DANR, over a year from the application being deemed procedurally complete. We have a hearing date scheduled. We now know that the venue is available. There's been conversations regarding the last time a uranium hearing occurred. It's my understanding that those were hearings on the actual mining application. The EX&I application had occurred much previous to that and took much less time. And that goes to the relevant consideration here, that of limiting the evidence presented to this board to that relevant to 45-60-29 being that relevant to an exploration permit rather than to a mining permit. It will require diligence by the parties and the board, but 3 days is sufficient time to consider the criteria set forth in 45-6D-29, assuming that the parties and the board maintain the appropriate level of admission and discussion of only relevant evidence. Thank you.
Thank you. Mr. Blair?
Mr. Chairman, Steve Blair, General Counsel for the department. I will admit I have some hesitation with 3 days. I know that the department's case, and I can only speak to the department's case, without cross-examinations, I would guess, just based on experience, having putting cases before this board before, would take approximately 4 hours. If you add cross-examination of parties into that, I don't know how long it would take. I don't know how long the applicant's case would take. There are a number of experts that have been noticed by the interveners. I don't know how long those cases would take. If you look at the total number of witnesses, expert and non-expert, we've heard that it's approximately 40. If all of those, direct and cross, took an hour, that's a 40-hour week, which would be approximately 5 days. There's also been some decisions made today regarding interpretive services. Again, we don't disagree with providing interpretive services, but there's recognition that that'll take up some extra amount of time during the hearing. Not a lot. It's not going to be a huge burden. People can adjust, but it's something that should be recognized. Also, the decision made today regarding Mr. Morris's relevancy decision, if you will, is going to require more time. There will be more objections made during the course of the hearing, more objections that will be argued, and the hearing chair will need to rule on. And so that's going to eat up time. And so, I mean, nobody wants to prolong this further. Certainly, I would like to get the case in and put it in front of you and allow you to make a decision. But the arguments of the interveners are, I think, well-founded that the statutes allow them to intervene. The statutes require a meaningful opportunity to participate. And based on where this hearing now sets, which is different than when Mr. Morris entered his initial order, that I believe necessitates considering additional days to the hearing. And, you know, also, when is the facility going to be available? How does that look? Is it bifurcated over a couple weeks? Is it all in 1 week? Is it 5 days? Is it 7 days? I don't know. PowerTech's been mentioned, PowerTech Encore. That was set for several weeks. It was the mining application. It was set for several weeks. I would think that an exploration application with this number of parties, again, just based on experience and what has happened in the past, could be done in 5 days. Other parties may feel that more time is needed, but I do think that to provide everybody a meaningful opportunity to participate in the process, put their issues in front of the board so the board can make a decision, I firmly believe that more time is needed. The applicant has, and the applicant's correct. Mr. Naz is right. That statute exists. It says 90 days, but due process also has to come into play. And we've entered into a litigious situation, and I'm not faulting anybody. I applaud those who have gotten involved as interveners. This process only works when citizens get involved, whether through hiring their own attorney or through pro se, and take the opportunity to have their voices heard in front of entities such as yourself. I applaud that. But they are parties now, and they are entitled to a meaningful opportunity to be heard. And so with those comments, I would encourage you to reconsider the schedule that's been set. Thank you.
Thank you. You may, but you need to come forward always.
So what I would like to add is, as you look at expanding the schedule, the Fall River County Commission, Oglala County Commission, and the City of Hot Springs approved funding the $5,870 3 ways. If you expand the schedule, that means more money to each of those entities. As a mayor, I can't expend money, so I can't authorize increasing the city's share of that. So we would need to hear back from you, as would Fall River County and Oglala County, how much you expect the cost to be in an expanded schedule. And then for the city of Hot Springs, that has to be put in front of council for them to approve the increase in the expenditure they've already approved. So what I'm getting at, I believe, is for you to make a decision today and know that those three entities are going to step up and fund that. I can't do that for you for the city of Hot Springs today because I can't authorize the expenditures of money.
Thank you. I have no order now. Applicant, go first.
Thank you, Mr. Chairman. You know, again, I think I need to start with the fact that the applicant has statutory rights to have this heard too and a decision be made. One thing I know for certain is that if we don't ever start it, we're never going to get it done. We all understand we need to get this done. We have 3 days scheduled in April. We can get it done in 3 days in April. The venue is available. There are issues with moving it forward to who knows when for who knows how long. The venue change was requested with the understanding that this would be a 3-day hearing on the merits, and that's the funding that the mayor and the other government entities acquired from their governing bodies. Let's have the 3-day hearing in Hot Springs. Let's get it done, and let's move forward. We're never going to get this done if we don't get it started. Thank you.
Thank you. Bruce? Mr. Ellison, I seem to offend or not offend people by using first names and last names, so we'll go with both.
So that's just fine. Thank you. Bruce Ellison, individual intervener. First of all, when you... Thank you, Ms. Miller. When the request for a change of venue motion was made, it was not made for 3 days. First of all. Second of all, when an estimate was requested of the board as to how much it would cost, the estimate that was given was for 4 days. So we already have an additional day funded. What I would state to you is that the interveners, the counties really understand what their responsibilities would be. When we were told that it was going to be, as I said, 4 days, that money was then discussed by the city council, was discussed the respective county commissions, and they approved it. And I have no doubt that that's going to happen again. So would ask that that not be a factor in your decision as to how many days you set for a hearing, and if you do want to bifurcate it, what's first and what's second. But currently, there's 4 days allocated in terms of the funding by the boards, by the department's own figures. Thank you.
Thank you. Anyone else? Yes, sir.
Very briefly, Mr. Chair, and I appreciate the opportunity to speak one more time. I do it to offer a potential compromise of the funding issue. If the hearing could be scheduled for the entire week of the 13th to the 17th, the applicant would be willing to pay for those additional 2 days of DA&R costs in order to get this done within that week. Thank you.
Doctor.
Dr. Lilia Jarding, Rapid City. If the applicant pays the DA&R for the hearing, that would look really bad.
Bruce, do you care to be heard?
Just briefly. Yeah, we'd welcome certainly any support that the applicant wants to give towards the hearing. Just simply changing it to, for 5 days to the 13th. I mean, that's not the schedule. We've been working on a schedule. If you're going to amend the schedule, we will work then with that schedule and whatever it is. But it shouldn't be based upon a blackmail to you that they'll guarantee, the company will guarantee an extra day of funding. We'd like them to do the whole hearing, and we'd like them to do as many days as they want to if they don't do the whole hearing. But that's not something, we have our obligations, the statute's clear who's supposed to pay for it, and it will be paid, and that is not the factor for determining when we go. We've already decided where we're going. We have to make sure when we can do it when it works, and I know you will. Thank you.
Thank you. Anything
Chair.
further? Yes.
I make a motion, we start on the 13th April and take it to the 15th at this time.
13th, so 3 days, starting the 13th.
You will start the 13th.
The motion is to have the hearing from April 13th through the 15th. 13, 14, 15. What Doyle, do you know what days of the week those are? I'm sorry, I'm not going to recognize.
Monday, Tuesday, Wednesday.
Monday, Tuesday,
I
Wednesday.
believe. Let me look at my calendar.
Yes.
Yeah, Monday, Tuesday, Wednesday.
13 or the other, not Monday. Right, right. There's a motion. Is there a second to that motion? Mr. Blair, do you have something to add?
I'm sorry, I just want a clarification of the motion. Is the motion to move the hearing to Monday, Tuesday, Wednesday?
That was part, it's a two-part motion. One part of the motion is to have a 3-day hearing, and the one's to change the date of the hearing from what it currently exists to 12, 13, 14.
13, 14.
13, 14, 15, sorry.
I can say I have a conflict on the 13th. I'll just put that out there now. So, with the circuit court. So, and I am the only lawyer, so I don't know if I can find coverage otherwise. But I'll just throw that out there. Thank you.
Thank you. That's the motion. I have not heard a second of the motion.
Mr. Chair, I'm not seconding the motion. I'm going to propose a motion to make it 5 days.
A substitute motion.
Substitute motion. Thank you.
Your substitute motion, we have to identify not only the days, but the dates that you are proposing, because we have to give everybody notice and opportunity to be heard.
I will just stick with the same week, just do the 13th through the 17th.
There's a substitute motion on the floor for a 5-day hearing starting on the 13th and proceeding through the 17th, which would be in Hot Springs. Now, I'm going to add this comment. I would like to check immediately to see if the facility is available. Can that phone call be made? Mr. Mayor, I'm picking on you. I don't want to agree to a hearing and a number of dates and then not have a facility.
I'm hesitating, aren't I? As I had mentioned previously, only council can approve expenditures or waiving of fees. I can't do that. Per South Dakota codified law, mayors, whether they're male or female, are either neutered or spayed. We can't spend money. So asking the council to extend to 5 days would be reducing revenue. To answer your question directly, I did confirm that the space is available since you asked the question directly and I had an answer. But I hope we're not being strong-armed in doing that. We want to participate in this. We want to make it happen. But I trust that we're doing it all for the right reasons here. And again, until I ask council directly whether they're going to waive those fees, I can't give you that answer today.
I understand that. We just need a facility.
Well, it's available with council's approval to expand it from 3 days to 5 days.
Understood.
And I can reach out to them individually and see how they want to deal with that and get an answer back. But I'm not going to be able to do that this afternoon.
No, I understand that. You
Okay.
have to do it the formal way. So whatever you need to do, and then we can make a motion approve of something with conditional approval.
Okay, thank you.
So we have a motion, which was, we have a substitute motion by Jessica. The substitute motion was for the full week. We know that the facility is available. We don't know what is going to be paid or not paid. Is there any further discussion by the board? Doyle? Well, I'm just discussing. Is there, there's a substitute motion. Is there a second to the substitute motion?
Mr. Chairman, this is Gary Haig. I'll second.
There is a second to the substitute motion. Is there further board discussion of the substitute motion, which takes the place of the original motion?
Yeah, this is Chairman Blumhart. If I don't feel right about Steve Blair not being there representing DANR on the 13th. I don't think that's right. I mean, that's their legal counsel to be there on that day. I really don't think we should cross into that territory without their legal counsel being available.
All right, but we need to get a date set today to proceed. How about that same date in May? Are you available, Mr. Blair? Are you looking at the week of May 18th? Yes. April or May? I am going to May. Well, Glenn doesn't want to do it if he's not here. That's April out.
Why don't you just keep the hearing dates as they are and then add more if you need them?
Oh. Are you available that date?
The week of May 18th?
Yes. We don't know if we have the facility. Go ahead, come forward.
Would it be possible to schedule the meeting Tuesday to Friday or Tuesday even to Saturday? If we're available, we can get this done still in April. I think those dates are set. Everyone's cleared their calendar. We're ready to be in Hot Springs that week to hear this on its merits. I think we need to get that done.
Point of order. We
Rhett.
did have a second. Should we?
Yeah, we have discussion of the current motion for the 5 days in April.
Okay.
And then we had a comment, but not another motion from Chairman Blumhart.
In order to clean things up, maybe we should vote on that motion.
Yeah, is there further discussion on, so what's pending right now is the substitute motion, 5 days, expanding what we had Monday through Friday in Hot Springs. That is the current motion, and we have a facility. Is there further board discussion?
Ready to vote.
You may.
In my age, thoughts come randomly. So I understood these folks are willing to pay for the expanded days beyond the 3 days. Is that correct? For the venue, okay. So that makes it easier then. Council's already approved 3 days and 4. So with those folks ponying up the rental fee for the facility for the additional day, that's a case that I can make to council that I hope they would be in favor of. I just want to make sure you folks are willing to pay for additional days.
We're not getting into the ponying up business.
They said it, not me.
Yeah, well, we get to decide, and I'm not a pony up person. That's got the wrong look. So we have a motion.
Can I call a question that we vote?
Yeah. The motion is 5 days. 13th, yeah, that whole week. Any further discussion of the board? Brenda, call the roll.
Ewing?
Did she call me?
Yep.
Yes.
Aye.
Grunwald? Aye. Haig?
Aye.
Carpin?
No.
Miller?
No.
Morse? Abstain. Schultz? Aye. Blumhart,
No.
Greenfield.
Aye.
Five yes, 3 no, 1 abstained.
Motion passes. Pardon me. I can't hear you. I'm old. Older. I'm not old. I'm older.
So I just want to be clear, we're doing this without Mr. Blair, and you're telling him to go and find a substitute counsel? Yes. Okay. One other question that I have is,
I'm not telling that's up to the AG's office on what to do. I would love to see Mr. Blair.
I have no objection to Mr. Blair being there, but
I'd love to see Mr. Blair, someone in their office, make his circuit court appear.
okay. What I'm wondering about by this 5-day motion, whenever you want to do it, and I guess if you want to start in April, we'll start in April. I just want to be clear that from my stand of view as an individual intervener, you're doing it at 5 days with the understanding we're coming back. Because, no? Okay, well, that's what I want to get clarified, because if you're thinking that we're going to get this done in 5 days, with all due respect, it ain't going to happen. I understand what the motion was for, but I was trying to get a clarification as to whether we were going to just do 5 days, and if we needed more time, come back, or if what the board was now voting on was, we're only going to have 5 days, we don't care what anybody wants to present. Because if that's what it is, then what I would suggest is we change the order of things. And we allow for the more lengthy cross-examinations, which will take place for the board's witnesses, for the CNEX witnesses and for the state's witnesses, because, you know, that right is pretty free and expansive of the right to cross-examination, fully to elicit the truth. And so you can start with, but we're just not going to end. So if you want to leave it that way, that we're going to be part way, and you're going to suddenly say, sorry, time's up, go away, you can do that. You can do it any way you want to. I'm trying to suggest that you come up with a plan that's realistic, and a realistic plan is not to have Mr. Morris just grant every motion that CNEC has for irrelevancy and move on, because we're not going to have a hearing. We're just going to have a circus.
Thank you. Mr. Blair.
Yeah, Mr. Chairman, I no longer work for the Attorney General.
Yeah, I knew. I just was informed.
As counsel for the department, I am the only lawyer for the department. I don't know if the Attorney General's office would provide coverage for the circuit court date. I don't know if the circuit court date could be removed, although circuit court judges' schedules are sometimes even harder than this board's schedule. So, but that is the reality, is that I don't know if there could be coverage or not. So, thank you.
But I know you'll check.
What's that?
I know you'll check.
Yeah, I will check.
Thank you. All right, that we have a motion and it passed, and we have the 5 days. Anything else for the good of the order? Please come forward. Yeah. We have to do public comment.
I just have a question about the brief on the treaty rights that has not been ruled on yet by Mr. Morris, because we don't know what that ruling is going to be, but my guess is one way or another there's going to be an appeal of that ruling regardless of what it is. If he rules in favor of us being able to present on treaty rights, then the applicant is going to appeal. If he rules against us, we're going to appeal. And you're trying to get this hearing done in April. So what Mr. Morris did on January 6th was he only asked for a brief from Mr. Capicella and Mr. Gunn. Mr. Capicella's party is no longer a part of these proceedings. However, I, with signatures from many other interveners, also submitted a brief on the treaty rights. And I think whether you're going to hear that today, or if you want him to rule on it and then bring us back here for another, or to Hot Springs, for another time for us to argue about the treaty rights. I'd like to have some kind of idea, because I'm gonna have to figure out financially how I'm gonna be able to come in and do that, because I have a right to be heard on that, and so do all the interveners that signed on to that brief.
And I have a response, and my response is that we can't take action under the statute that we're going on until there's a ruling.
Okay.
So that we have no ability to tell you today, yes or no.
I understand
We do
that.
have the ability, however, before the hearing starts, to go through the same process that you went through here today. And in my mind, that's what we would do. The hearing would start by that.
Okay.
Does that answer your question?
Yeah, so is there a time limit then for Mr. Morris to rule on our briefs? Actually, on the brief that is now solely from the interveners, because I don't think one was submitted by the attorneys.
I,
Mr. Gunn submitted a brief.
Oh, did he? Okay, I didn't get to see that on the record, which, if electronic service was allowed, I would have had it by now.
Thank you. Did that answer your question?
Kinda. I'm still trying to get a answer as to when are we gonna have a ruling on that, and what the timeline would be for us to be able to put in responses and things like that, because my brief is pretty extensive also.
Thank you.
Thank you.
We cannot adjourn. We have public comment. Is there anybody live or on air that wishes to make a public comment? You are done. Thank you for your service. And I don't know what you're going to do with the original exhibits, but if you could attach those to the transcript, the original transcript. Yeah, Brenda said she'll do it. Any public comment? Hearing none, there might be one more motion to make. You get to guess. There's been a motion to adjourn. Is that motion seconded?
Seconded by Miller.
Seconded by Miller. Voice vote. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. Thank you, everyone.